May I please, your lordships? Item 25.
Yes, 25.
This matter pertains to a land dispute between two villages. Mr. Takamasa and City Jamir have been appointed as the mediator to make reconciliation. Several round-up talks have been taken place, and the parties have also visited the site, including the mediator. The spot verification was also conducted. And thereafter, the dispute has been narrowed down to a very small area. And then we were hoping that this will be resolved very soon. But then it is taking more than the expected time. So today, I would pray that another 3 weeks' time may be allowed so as to enable the parties to arrive to an amicable solution. The talk is going on still, and the area is confined, narrowed down to a very small area. So 3 weeks' time may be allowed, lordships.
Okay. Who is appearing for the
Item
respondent?
25.
Yes, who is appearing for the other side? Yes.
Takamasa, due to some personal difficulties, he could
He has
not be
not
present.
appeared.
Yes, but he has
Okay.
consented me also.
Heard Mr. C.T. Zamir, senior advocate, who submits that himself and Mr. Takamasa,
Yes.
senior advocate, have been appointed as mediators, and the parties are making an attempt to come to an amicable settlement. That the parties have come to some settlement regarding some areas in the disputed land, and the learned counsel for the appellant, senior counsel, okay, for the appellant, has prayed that they may be given another 3 weeks' time, by which they hope that the parties will be able to come to a full settlement with regards to the disputed land. In view of the above, we find it fit to list that this matter may be listed again after 3 weeks.
3 weeks. Obliged, lordships.
May it please, Lordship. Lordship, I'm back to mention item number 22 for orders, Lordship. In this case, Lordship, I have instruction to appear on behalf of respondent number 1, 3, and 7, Lordship. I may be given some time to file my power as well as the affidavit, Lordship. 2 weeks' time, Lordship.
I'm appearing for a petition on this matter. May I pray that the matter may be taken up on a fixed date so that it will be easier for us to approve?
Okay.
Can it be on 24th of May? And by that time, I think they will have enough time to file their affidavit.
Heard Mr.
Mojame, Lordship.
Mojame, learned counsel, who mentions that he will be appearing for the respondents number
1, 3, and 7,
1,
Lordship.
3, and 7, and has prayed for time for filing his power. Mr.
A. Sharma
A. Sharma, learned counsel
for the petitioners.
for the petitioner, prays that a fixed date may be fixed, and has prayed that the matter may be listed on 24/5, 2023. List the matter on 24/5, 2023 as prayed for.
To enable them to file the affidavit, if so advised. Let that be there.
In the meantime, the respondents are to file their counter affidavit, if any.
Obliged,
Much
Your
obliged.
Lordship.
Your Lordships, I beg to mention item 24.
24.
Yes. On the consent of the parties, I pray that this matter may be listed after 2 weeks.
Heard Mr.
L. Iral.
L. Iralu,
For the appellant.
learned counsel for the appellant, who prays that this matter may be listed after
2 weeks.
2 weeks, and that the consent,
Yes, lordship. I'm appearing for respondent number
Okay.
3 and 4.
and that the consent of the respondents have also been taken. Mr. So-and-so, learned senior counsel, appears on behalf of respondent number 3 and 4.
3 and 4.
In view of the above, list this matter after 2 weeks.
I'm obliged.
Maybe, His Lordship, on behalf of my senior, I picked to mention item 18. I pray that the matter may be come up on 26. Petition item number 18.
We have to deal with the IA, isn't it? A delay of how many days? 2,656 days.
Yes, Lordships.
So has the written objection been submitted? Who is appearing
Not yet, Your Lordship.
for the opposite party in the IA?
Your Lordship, here, I think to mention that in view of the Order 47, Rule 5, and this is order will be passed and refer to the appropriate bench.
No.
Because it's a
18.
review.
1-8. 1-8 is a review petition.
Yes, but
It's a review petition, but the review petition has also been filed along with an IA.
yes,
IA is for condonation of delay of 2,656 days.
yes,
So the condemnation, I think the IA can be disposed of before any bench, and then the main review petition will have to be heard before the appropriate bench, isn't it?
because the I also related to the review.
Okay.
That's why I just,
Heard.
yes.
Okay, with the review, though the issue is completely different.
Yes.
The IA
Yes.
is simply for condonation of delay, okay? While the review is with regards to whatever your grievances against the judgment. So I don't think the IA needs to be listed before any appropriate bench. Anyways, since you're afraid, yes, I've got your point. Heard, Mr. The petitioner first. Who is the petitioner in this case?
I'm the appellant, Your Lordship.
Appellant, yes. The applicant, who is the applicant? You are the applicant. Heard, Mr.
Sobhamwati.
Somangwati Wali. Is it
Yes, Lordship.
learned counsel for the appellant who has prayed for adjournment, mentioning that his senior, Mr.
Imti Longchar.
Imti Longcha, is not able to appear today due to personal difficulties. Mr.
Yeah, I'm for the state respondent.
Mr. Joshua,
In team, so
okay,
additional
okay, Mr. Imti, learned additional
AG.
AG mentions that this matter has to be listed before the appropriate bench,
Appropriate.
since this is a review petition. In view of the above, the registry to do the needful and list the matter after 2 weeks, or and list the matter when the appropriate bench is available.
Your Lordship.
Obliged, Lordship.
May I please, Your Ladyship and Your Lordship, beg to mention item 23. Kindly grant me 3 weeks' time to file affidavit in the opposition.
23.
Item 19.
Heard, Mr.
Kiangami.
K. Amgami, learned government advocate, who has prayed for time to file their affidavit in opposition. None appeared for the petitioner.
I've taken consent.
Okay, for the, who has prayed for time for filing of their affidavit in opposition, and that the consent of the petitioner has also been taken in this regard. In view of the above, list this matter after
3 weeks.
3 weeks. Are you
Lordship.
appearing for the petitioner?
Yes, Lordship, I'm for the petitioner.
Then you mention Mr. So-and-so makes
Yes.
appearance on behalf of the petitioner. In view of the above, list the matter after 3 weeks.
Blush, Your Lordship.
Yeah, please, Lordship. Lordship, I beg to mention item 14. Lordship, here, Advocate General is leading the case. So, Lordship, I pray that the matter may be fixed on 10th of May.
Is that the day when the DB is supposed to sit?
Yes, Lordship.
Heard Ms. Shuri, learned government advocate, who mentions that this matter is being taken up by the
Advocate General.
okay, AG.
Yes.
And has prayed that this matter may be listed on 10/5/2023. Miss so-and-so makes appearance on behalf of the
For the
petitioner.
private respondents, Lordship.
Okay, makes appearance on behalf of the private respondents, while Mr.
Ajo is for 18 to 23. 18 to 23. Mr. Ajo,
Okay, Mr. So-and-so makes appearance on behalf of,
18 to 23, private response. 18.
on behalf of the private respondents. Accordingly, list the matter on 10/5/2023.
May it please your Lordship. I beg to mention item number 10, your Lordship. If I may be allowed 3 weeks' time to file affidavit in reply, your Lordship.
Third, Miss
Libeni Bijungyo.
Lipe Bichumi, who has prayed that,
Lordship, in this case, Lordship, on 2 occasions, the this honorable court has directed state respondent to go for verification.
yes,
And on 2 occasions, we have gone for verification. And accordingly, we have filed an affidavit. The complaint as per the direction of this honorable court. Lordship, now the matter is. Lordship, the prayer of the petitioner in this case is Lordship. Lordship
Yes.
may kindly.
I think it's regarding the compensation that has to be paid.
Lordship,
No, not compensation, money, isn't it? Pradhan Mantri,
Yes,
Garib something.
Lordship,
Okay,
Lordship.
yes. So you're supposed to receive,
Lordship, here the petitioner
Yes.
is aggrieved by 365 families. They are aggrieved that saying that they
Garib
have not
Kalam,
received the food grain, Lordship.
yes, yes.
And accordingly, this honorable court on 2 occasions has directed the state respondent to go for verification.
Yes,
And on 2 occasions, we went for verification, and accordingly, we filed the affidavit.
yes.
And basing on that, Lordship, time and again, the petitioner, they are seeking time, Lordship. However, Lordship, now it will be a futile exercise if we go for the third verification, Lordship. So, Lordship, if Lordship may kindly come to the prayer portion, Lordship. Starting from page number 31. The main petition, Lordship.
Yes,
May I read, Lordship? Page
Yes.
32, relevant page 32, KL, the last paragraph, Lordship. Page 32, the prayer portion, Lordship. May I read, Lordship?
yes.
L. Direct the respondent to file complaint before the appropriate court on the allegation of corruption activities for the last 20 years by offender, former village council chairman, village council member Gaumbaras. A.
Yes.
Direct the respondent to grant license for the fair price shop to the women group or any other honest person in Chenmoho village. B. Direct the respondent not to reappoint the offenders involved in the case for the fresh new tenure of village council in the interest of justice. C. Direct the respondents to ensure that persons with honesty and high integrity are appointed in the present tenure of village council for Chenmoho village. D. Direct the respondent to comply with section so-and-so 27, 28, and 29 of the National Food Security Act 2013 by making the related records of targeted public distribution system, fair price shop, including the list of beneficiaries, accessible to the public by uploading it in the website of the Department and Food and Civil Supplies, Lordship. So, Lordship, now, if we go by the prayer, Lordship, now it's a disputed question of facts, Lordship. So they have to approach the appropriate forum, appropriate court, Lordship. So the appropriate, as far as the prayer is concerned, Lordship, they have to approach the civil court, Lordship.
See, in the Lord's court's order,
Lordship.
you have submitted the affidavit in compliance
Lordship.
and
On 2 occasions, Lordship.
and you were directed to file affidavit to bring on report the aforesaid report. So you have filed that.
Lordship, that we have
Now,
done.
if I'm not mistaken, now the petitioner can find out whether they have actually received the monies or the grain as per their report.
Lordship,
And if they have received it,
Lordship,
then this is a PIL.
Lordship,
So that this PIL itself can be closed.
Lordship.
Isn't
It
it?
can be closed, Lordship.
It can be closed.
It can be
No, Your
closed.
Lordship.
So you have prayed for time for filing your affidavit in
Lordship,
reply.
Time and again, Lordship.
So you have filed your time for this thing, find out. And
Yes, Your
if
Lordship.
as per their report, they have all received, then there you have no grievance.
Yes, Your Lordship.
Lordship,
In the next stage, Your Lordship.
Find out, because you all have filed this PIL aggrieved that they have not received the food grains. And the state respondents have said, we have already given the state this thing, food grains. We can close it now, but since you have prayed for time for filing of your reply affidavit, it will be most probably to verify whether they have actually received or
Lordship.
whether they still have some grievances.
Lordship,
Yes, Your
compliance
Lordship.
affidavit is filed in the month of December 2021, Lordship. Now
Okay.
this present PIL is been dragging for almost 2-3 years, Lordship, to get the instruction from the client, Lordship.
Okay, we'll give them a final chance.
Lordship,
Yes, Your
Otherwise,
Lordship.
we'll presume that you have nothing to, no more
Lordship.
grievances, isn't it?
Lordship, that may be reflected in the order, Lordship.
Yes. Heard Miss
Libeni Bichungyo.
Libene Bichuno, learned counsel for the petitioner, who has prayed for time for filing of the affidavit in reply to the affidavit filed by the state respondents.
Lordship, in the month of December 2021.
Mr. So-and-so, learned government advocate, mentions that the compliance report in the form of an affidavit has been submitted by the state respondents in the month of
December 2021.
December 2021. And the petitioners have time and again prayed for filing of the reply to the affidavit of compliance filed by the state respondents. He has prayed that this PIL is ripe to be closed
Lordship,
since all the needful has been done by the state respondents. We, however, find that it would be appropriate to give a final chance to the petitioners to file their reply, if any, with regards to the compliance report submitted by the learned state respondents. In view of the above, list this matter after
3 weeks, Your Lordship.
3 weeks.
Much obliged, Your Lordship.
May I please, Your Lordships? I beg to mention item number 11. I'm mentioning on behalf of the National Investigation Agency, Lordship. Lordship, here the leading counsel, Mr. N.N. Mishra, who was the leading counsel for this matter, his engagement tender has got over, Lordship. And so the new incumbent is yet to engage. So I'm mentioning on behalf of the NIA to pray for 3 weeks' time, Lordship, until the next engagement comes in for leading the case.
Heard Miss
Apila Sankam.
Apila Samgam, who mentions on behalf of INA that the leading counsel in this case, Mr. N.N. Mishra's term is over and that they have yet to file another leading counsel in this matter. She has just prayed that this matter may be listed after
3 weeks, Lordship.
3 weeks. Miss
Miss Lucino.
Ms. Lucino appears on behalf of the state on behalf of the respondents.
Lordships, a similar prayer for item number 13 and 16 as well.
List this matter after 3 weeks. Yes, 13
13 and 16, Lordships.
and 16.
Lordships.
11, 13 and 16.
16.
Same order.
Obliged, Lordships.
May I please, Your Lordship? My Lord, I beg to mention item number 26. My Lord, I'm appearing on behalf of MD Imsong Additional AG, my Lord. Let the matter be taken up on 26 next week.
See if it's on the 26th next week. And we have a full hearing. This bench is not likely to sit again after that. So we'll make it after 2 weeks or after. Yes, if we have full hearing, then we are going on with the series. This bench will not be sitting again.
Lordship, I have no objection.
So let's fix it when not this bench, but the next bench sits and immediately on the first week, isn't it?
Your Lordship.
Heard Mr.
E.T. Papom.
A.T. Bopon, who appears on behalf of the learned AG, and Mr.
Tongpok Ponganer.
Tongpok Poganer, learned counsel for the appellant. On the submission made by the learned counsel for the respondent, this matter may be adjourned and be listed on, yes. So when will be the next date? On 3rd May?
Third May.
On 3rd May 2023.
Much obliged.
Next, Lordships. Lordships, I beg to mention item 23.
Item number 23.
Lordship.
Yes.
Lordships, if this matter can come up next week or after 2 weeks.
What happened?
Lordship, here I'm led by Miss S. Mehdi. She's an outstation lawyer. She couldn't get today, so I'm for response number 3, 4, and 5. So if
Okay. Heard Mr. Fokesto Fote. Okay. Learned counsel for respondent number 3 and 5.
3, 4, and 5.
3, 4, and 5, who mentions that he is led by Mr. S. Miss
Yes.
S. Mehdi, who is an outstation counsel, and that this matter may be adjourned for 2 weeks.
2 weeks.
Miss So-and-so makes appearance on behalf of the appellant.
Appellant.
Yes. In view of the above, list this matter after 2 weeks.
Obliged, my Lord.
May it please, my lords. My lords, item 27 and 28 in the supplementary cost list, motion item.
Yes.
It appears it has been wrongly listed before this division bench, my lord. It
Okay.
ought to have been listed before the single bench as per Chapter 2, Rule 7B of the Gauhati High Court rules.
No, it has to be listed. most
Before the
probably.
single bench.
My
Single
lord.
bench. Heard Mr.
Sendiyangar, my lord.
Sandhya Yagar, learned counsel for the appellant, who mentions that this matter should be listed before a single bench and not before this bench. In view of the above, this court find it fit that this matter should be listed before a single bench, the registry to do the needful.
My lords. 28 also, sir. It's connected,
Yes,
27
yes,
and 28.
27 with 28.
My lord. Deeply obliged.
Motion, item number 1.
May it please your lordships. My lord, Justice Kadak will recall when this matter was listed last week on whether this matter should be listed before the learned single bench or the division bench. Now, going by the Chapter 2, Rule 7, the punishment is below 10 years, so it should be listed before the learned single bench. But at the same time, your lordships will kindly appreciate that if we go by Chapter 2, Rule 7A. That today there is no single bench constituted. So in the absence of the single bench, the learned division bench can also pass an order. And this is to do with Article 21 of the Constitution. The accused person, the appellant is behind bars. So if at least a condonation of delay can be decided by this learned division bench before reverting the matter before the learned single bench.
What about the government advocate? This he will be the PP, isn't it? This is a criminal matter. Anyways, what do you say? Okay. This matter involves Article 21. Okay. However, since a single bench is sitting tomorrow,
My lord.
awaiting just, it will be how many? It will be less than 24 hours because the court starts at 10:30. Okay. I think
Your
we can
lordships.
wait.
Lordships.
Okay. Yes. Heard Mr.
Joshua.
Joshua Sekar, learned counsel for the applicant slash appellant, who mentions that this matter is to be listed before a single bench since the sentence imposed is less than 10 years.
Lordship.
However, due to the urgency of the matter, he prays that this bench may consider the IA, which is for condonation of delay.
Of 51 days.
Condonation of delay of 51 days. However, this court finds that, we find that since a single bench will be sitting the next day, that is tomorrow, it may be more appropriate if this matter was listed before a single bench, the registry to do the needful and list this matter on, what's tomorrow? 20.
Tomorrow is 20.
20 for 2023 before the single bench.
Bless your lordships.
For motion item number 2.
May it please your lordships. Your lordships, this is one rare case in Nagaland where a false rape case has been instituted against the appellant. Your lordships will kindly appreciate one fact, which is 100% contradictory. The statement of the victim's partner, the child witness, and the medical record. 100% different, your lordships will kindly appreciate that. The medical records clearly show that no injury whatsoever, and the blood stain, that was the cause on how the case was instituted. It turns out to be what we call it as a monthly cycle of female gender. Your lordships, if your lordships go through the evidences, which at the course of hearing we will appreciate all those, but as we go through the statement of the witnesses also, your lordships will appreciate this fact that it's very clear that the witnesses, the child witnesses, they were trained witnesses. It's 100% contradictory with the scientific findings. So,
Okay, will you show notice first? Will you show notice?
your lordships, but in the meantime, at least the judgment may be stayed so that
With notice, we'll hear both the parties first. Okay.
it's only the
We
state
will
respondents.
we will admit that heard Mr. Joshua Sekar, learned counsel for the appellant, who has filed this appeal under section 374 of the Code of Criminal Procedure against the impugned judgment dated
13/3/2023.
2023 and the order dated 15/3/2023, passed in GR number 18/2021 by the learned special judge, POXO, Zeheboto, Nagaland, wherein the appellant was sentenced to undergo rigorous imprisonment for a period of 20 years with a fine of rupees 20,000 under Section 4 and 6 of the POXO Act, read with Section 376 within brackets 2 within brackets LIPC, in default of which the convict will have to undergo another 1 year of rigorous imprisonment. The learned counsel for the appellant submits that there are sufficient grounds for setting aside the sentence, the conviction and sentence of the appellant, which is apparent from the statement of the witnesses and the medical evidence.
Lordship.
On hearing the learned counsel for the appellant, we find it fit to admit the appeal, issue notice upon the respondent, state respondent. Now, in this appeal, isn't the informant to be made a party? Have you made them a party?
No, Your Lordship.
I think that's necessary. Respondent number 2. Isn't it? Issue notice upon the state respondents. It is seen that the informant has not been made a party in the writ appeal, and the learned counsel for the appellant is to take steps to make necessary corrections by hand. You can make the correction by hand.
Your Lordship.
Okay, in the appeal petition by including the name of the informant, wherein notice is to be issued upon both the respondents. Mr. Enangami, okay, learned PP accepts notice on behalf of the state respondent. Issue notice upon respondent number 2. Please make the corrections.
Lordship.
Okay.
Lordship.
Through registered post with AD, returnable by 3 weeks.
Your Lordships.
Steps will be taken for issue of notice within 3 days. List the matter after 3
yes.
weeks.
Yes, Your Lordship, and interim may be considered on the next date.
Yes.
The other IA is for bail. If interim is not granted, Your Lordships, the bail application cannot be taken up today. I have an application for bail also.
The learned counsel for the appellant praised that the IA, which has been filed along with the appeal petition, may be considered in the next date. Notice, I think we'll make it a fresh this thing. We'll pass that order in the IA. Okay. So you cancel that. We'll make it heard, Mr. So-and-so. Josias Sekhar, learned counsel for the applicant/appellant, who submits that he has filed this application under Section 389 Criminal Procedure Code for suspension of the judgment dated 13/3/2023 and order dated 15/3/2023 in GR case number 18/2021 for release of the appellant on bail on the terms and conditions deemed fit in the interest of justice pending the disposal of the appeal. Notice is to be issued upon the respondents, Mr. N. Angami accepts notice
No,
on behalf
Vijmomi.
of
Vijmo.
B. Zomomi.
Lord.
Learned PP
Lordship.
accepts notice on behalf of the state respondent. It is seen that in this also, the respondent number 2 has to be there.
Yes. Yes, Your
It is
Lordship.
seen that the respondent number, it is seen that the informant in the case has not been made a party, and therefore the applicant slash appellant is to make necessary corrections by hand in the application filed by making the informant a necessary party. Notice is to be issued upon the informant slash respondent number 2 through registered post with AD within 3 days, returnable by 3 weeks. List this matter after 3 weeks. Yes.
Oblige, Your Lordship.
For motion item number 3.
Please, Your Lordships. Your Lordships, this present writ appeal is filed impugning the Honorable Single Bench Judgment and Order dated 4/2/2023, Your Lordships, for which I have also filed an IA for continuation of delay of 26 days, Your Lordships.
So I think we'll have to issue notice first. Okay, and the government, this is 26 days.
Yes, Your Lordship, 26 days.
Are you going to file any objection?
Not necessary, Lordship.
No objection. So we'll condone the delay? Yes. Heard, Miss?
R. Atsla Kips.
R.
Atsla Kips.
Atsla Kips, learned counsel for the applicant slash appellant, who submits that this is an application under Section 5 of the Limitation Act, 1963, praying for condonation of delay of 26 days in filing the present writ appeal against the judgment and order dated 14/2/2023, passed in writ petition number 169 of 2019 by the single judge of this court. The learned counsel submits that the delay of 26 days in filing the writ appeal is mainly due to what?
The reason is stated in paragraph 4 of my IA, Your Lordships.
What does paragraph 4 say?
If I may be allowed to read, Your Lordship. That the counsel of the appellant obtained a certified true copy of the judgment and order dated 14/2/2023 on 16/3/2023. Thereafter, the counsel for the applicant appellant called the applicant appellant from Dimapur to discuss the need to file an appeal before this honorable court, but the applicant appellant could travel to Kohima to discuss the issues only after the General Assembly elections on 6th of March 2023. Thereafter, the appellant was explained about issues giving rise for need to appeal before this honorable court, due to which delay was caused. As such, the delay cannot be imputed against the appellant petition. This there is in Your Lordship.
Okay. Mentioning that the delay is due to the time taken to obtain the certified true copy of the judgment and order dated 12/02/2023, and since the applicant appellant is residing in Dimapur, time was taken to travel to Kohima to discuss the appeal, which was further delayed due to the elections, General Assembly elections held on 6 March 2023. Mr. So-and-so, learned government advocate, accepts notice on behalf of the state respondents and has not raised any objection to the condonation of delay of 26 days. In view of the above, we find it fit to condone the delay of 26 days in filing the appeal against the judgment and order dated 14 so and so. Accordingly, IA number 40/2023 stands allowed and disposed. Now, in the main appeal on the disposal of IA number 40/2023. Yes. What is the writ appeal about?
Your Lordship, here the appellant, being the petitioner, Your Lordship, approached the Honorable Single Bench, Your Lordship, by filing that is WBC 169 of 2019, seeking for regular scale of pay with all consequential benefits from the date of her illegal termination, Your Lordship. That is, she was terminated. The appellant was terminated on 4/7/2011, Your Lordship, and she was reinstated on 15/8/2019, Your Lordship. So for that matter, the appellant is a petitioner, Your Lordship, approaches Honorable Court, Your Lordship, seeking for consequential benefits, back wages, Your Lordship. However, by the Honorable Single Bench judgment and order, which is in my Annexure 19, Lordship, Annexure 1, Your Lordship, page 19. This is my writ petition, Your Lordship, and the Honorable Court order is in
Okay, will issue notice first.
Page 79.
Your Lordship, relevant paragraph is in, I'll just read the relevant paragraph, Your Lordship. Page number 90, Your Lordship.
90?
Yes, Your Lordship. I'm reading from paragraph 11, Your Lordship. In the instant case, it is seen that the Honorable Division Bench has only directed the state respondents to immediately reinstate the petitioner back in the service as a regular peon in the office of the EAC Aganaga, and no directions have been issued for payment of the pay scale retrospectively from 4/7/2011. In compliance with the order passed by the Honorable Division Bench, the Deputy Commissioner, Dimapur, Nagaland, with the prior approval of the government, has issued the order dated 16/8/2019, reinstating the petitioner as a regular peon in the office of the EAC Akanaga. It is further seen that neither in WBC number 153K of 2013 nor in the writ appeal number 21K of 2017, relief has been claimed by the petitioner for payment of regular pay scale from 4/7/2011 onwards, and it is only subsequent to the passing of the judgment and order dated 28/5/2019 in writ appeal number 21K of 2017 that the learned counsel representing the petitioner has served the notice dated 11/6/2019 to the state respondents to comply with the judgment and order and to pay all arrears salary from 4/7/2011. It is only thereafter that the present writ petition has been instituted. Paragraph 12. It is therefore discernible that the petitioner herself has contributed in belatedly claiming the salary from a retrospective date, which is the subject matter in the present petition. This court is therefore not inclined to direct payment of regular pay scale to the petitioner with retrospective effect from 4/7/2011 up to 15/5/2019 as claimed by the petitioner. However, considering that the petitioner was illegally removed from the regular service of peon and was deprived the pay scale attached to the post of 8 years prior to the filing of the present writ petition, and taking into account the attending facts and circumstances of the case, this court is of the view that the petitioner shall be entitled to receive the regular scale pay of office peon with effect from 3 years immediately preceding the filing of the present writ petition, but minus the consolidated fixed pay already received by the petitioner as contingency typist in the office of the Additional Deputy Commissioner. Newland, during the said period, no other allowances, consequential benefits, etc. is allowed. The state respondents are directed to make the payment to the petitioner within a period of 90 days from the date of passing of the order, failing which the amount ordered to be paid shall carry interest at the rate of 9% per annum till final realization. Your Lordship, in the petition, Your Lordship, the petitioner appellant was seeking for full back wages, that is from the initial date, from the date of her termination order, reinstatement order, Your Lordship. However, the single bench have only directed with effect from 3 years, Your Lordship. That is from the date of the filing of the writ petition, Your Lordship.
Okay. We will, the same issue notice will be accepted by, isn't it? On the disposal of IA so-and-so, heard Miss so-and-so, learned counsel for the appellant, who submits that the appeal is preferred against the judgment and order dated 14/2/2023, passed in WC number 169/2019. Since the learned single bench had not granted the full, what was it, the full?
Back wages, Your Lordship.
Back wages as prayed for in the writ petition, whereas the appellant is fully entitled to be paid the full back wages. Notice is to be issued. Mr. So-and-so, learned government advocate, accepts notice on behalf of the state respondents.
1 to 8.
1 to 8.
Yes.
Any private respondent? No.
AG 9. 9 is AG, I think.
Issue
Accountant
notice
General. Right.
Upon, are you sure? Are you sure it's 9?
Yes, Your Lordship.
Issue notice upon respondent number 9. True registered post with it AD, returnable by 3 weeks. The appellant to take necessary steps within 3 days. This matter after 3 weeks.
My lady.
I oblige, Lordships.
Requisite
Necessary, yes, requisite copies of the writ appeal to be furnished upon the learned GA.
I oblige.
Item number 4.
Maybe Your Lordships.
Yes. Yes, again, this will be similar then. It is a
Yes,
review
Lordship, but
petition.
I have a submission, Your Lordships.
Huh.
On the last occasion, that is on 12/4/2023, the registry were directed to take appropriate steps to get it listed before the appropriate bench, Your Lordships. But then since no formal order was passed, Your Lordship, I pray that an order may be passed directing the registry to take appropriate steps so that the matter may be placed before appropriate bench.
Yes, item number 4. Isn't it? Heard Mr.
Subhamwati.
Sowanwati Wali, learned counsel for the applicant / appellant, who submits that this matter is required to be placed before the appropriate bench. Mr. So-and-so, okay, you're for?
Yes, I'm representing Lordship 1 and 3.
Respondent number 1 to 3 is present along with
I'm for respondent number 2 and 4, Lordship.
Mr. So-and-so for respondent number 1 and 2. In view of the above submission, we think it fit to direct the registry to list this matter before the appropriate bench, since this is a review petition. Okay. Yes, matter to be listed once the appropriate bench is available.
Obliged, Lordship.
For motion, item number 5.
Yes, Lordships. Lordships, in the IA 39, on the last occasion, I have sought time to file an objection
Yes.
in IA 39.
Oh.
Lordship, but I've been instructed that they are getting some documents. So if Lordship may kindly let this matter come up next week, Lordship. In the meantime, I'll file my...
IA 39 is concerning what? It is-
Lordship, this is a small application, Lordship.
Okay, renovation and
Lordship.
improvement.
Lordship.
Under what provision of law have you paid for this?
Lordship, under section 151 of CPC, Lordship.
151.
Lordship.
Have you mentioned that in your application?
You don't mention.
Lordship, my apology, Lordship. It is typography.
No mention is made.
Anyways, that's one point.
Lordship, I need some more time to file my objection in this IA.
Heard Mr. So-and-so who has prayed for time for filing of his written objection against the IA.
Lordship, Lordship, as this is a very small petition, Lordship. Lordship, my grievance is that, Lordship, I am totally hand to mouth now, Lordship. And Lordship, your Lordship will appreciate the fact that as this is a festive month, Ramzan, Lordship, my business establishment, Lordship, it has been closed down since more than a month, as the roof of my shop has collapsed. And I'm seeking a small order from this honorable court just to modify the status quo order passed in the connected appeal, Lordship, and to permit me to just repair the ceiling, Lordship.
You see, in your IA, my concern was that
Lordship.
I had glanced through your IA,
Lordship.
that under what provision of law have you approached this court? And now you're mentioning it's under 151, but this has not been reflected in your application.
Lordship, I beg apology, Lordship.
So I think you
it
can
is
make that
a
amendment
inadvertent
also.
mistake, Lordship. I beg apology, Lordship.
Simply submitting a blank prayer like that before the division bench is not appropriate.
Lordship, I beg apology, Lordship.
Maybe he can make the amendment, what do you think, or we accept his verbal submission? Yes, please.
This IA under 151 CPC.
Lordship.
How? 151 is what? What is
Lordship.
the provision?
Lordship, inherent power of this honorable court, Lordship.
You better amend.
I
Lordship.
think you should amend.
Lordship, if I may be permitted to correct it by hand with this, the leave of this honorable court.
Okay.
Highly obliged, Lordship.
Can be done under 151, but you're praying for, just technically, you're praying for the modification of the interim order which was passed, isn't it?
Lordship.
So that status quo be maintained.
Lordship.
Okay, it can be under 151, but I was thinking maybe should have been. Anyways, it's for the objection to be filed. Heard, Mr.
Prosecco.
V. Dim.
Lordship, sorry.
This is number 5. Yes, I think you have mentioned that you have prayed for time.
Yes, Lordship.
Okay, filing of
I'm
the
for respondents,
objection,
all
yes.
respondents.
Yes,
1 to 11.
responded. While it is noticed that the IA, the instant IA does not mention under what provision of law the IA has been filed. Mr.
V. Devnath.
Devnath, learned counsel for the applicant, clarifies that the application has been made under 151 CPC and has prayed that he may be allowed to make necessary corrections by hand on the application so submitted. We find it fit to allow the applicant to make the necessary corrections in the application. list this matter again on,
After a week, Lordship.
list this matter again after 1 week.
Oblige, my lord.
Oblige.
For admission, item number 6, 7, and 8.
Yes.
May it please your lordships, in this petition, I am impugning the service rules, namely Nagaland Employment and Craftsmen Training Service and Nagaland Subordinate Employment and Craftsmen Training Service Rules of 1998. Lordship, before I go into the background facts of the case, I would like to take your lordship to the impugned service rules, the provisions which I am impugning in the instant petition. The service rules is at Annexure E, your lordships. Annexure E, page 63. This is the rules. And your lordships, I'll take your lordships to the relevant provisions. Page 66, your lordship, this is the section, rule 3. Page 66, your lordship. Rule 3, constitution of service. So there are two wings. The petitioners are under the craftsman training wing, that is, which falls under P category, and A category, the private respondents come under the employment wing. So your lordship, it is very clear from here. The service shall consist of the following wings headed by director, and under the wing of the following categories of posts shall be consisted. So director at the apex, and then the equivalent posts of the two wings. Your lordship, it is very clear. Number 1, Nagaland Employment Service, class 1. Under this, they have senior grade 1, which is the joint director, B, senior grade 2, that is deputy director, regional employment officer, and C, junior grade assistant director, district employment officer. Equivalent posts under the craftsman training wing are number A, senior grade 1, joint director, B, senior grade 2, deputy director, principal, senior grade C, junior grade assistant director, principal. So these are the equivalent posts, and these two wings are, as per the rules, very clearly equivalent to each other. Even the manner in which they are appointed, the classes, they are exactly similar. Only the designations are different, your lordship. Now, below that, Nagaland Employment Service class 2, and so on it goes. But the present petitioners are the petitioner number 1 who filed, the petitioner number 1 has withdrawn from the case. He took voluntary retirement, your lordship. Now from the petitioner number 2 onwards, we are contesting the instant petition. So the petitioner number 2 is presently deputy director, and the others, they are of the rank of assistant directors, your lordship. Principals and vice principals, your lordship. So this is the breakup. It's clearly laid down. Now, what I am aggrieved with is the schedules, your lordship. This is where the problem arises, the schedules. Page 75, your lordship. I am aggrieved by Schedule 1, Schedule 1A, 1B, 2A, and 2B, Your Lordship. I'll take Your Lordships to them one by one. Schedule 1A and 1B, Your Lordship. So these are the numbers of posts that have been sanctioned posts. So-called sanctioned posts under the two wings. The first one, Schedule 1A, deals with the Nagaland Employment Service. If Your Lordship may go to P senior grade. Number A is with regard to the director. So there is only one post of director. Now from P onwards, Your Lordship, Nagaland Employment Service Class 2, Class 1. Number 2 is P senior grade 1, joint director. There is one post available. C, senior grade 2, deputy director. There are altogether 3 posts. One is permanent and 2 are temporary, Your Lordship. And altogether there are three posts assigned. 4, regional employment officer. This also falls under deputy director, Your Lordship. 1 post. So altogether there are 4 posts of deputy director in the employment wing, Your Lordship. 4 posts altogether. Then assistant director, 2 posts. Now, Your Lordship, I'll take Your Lordships down to Schedule 1P. With regard to the craftsman training, that is the present petitioners, senior grade 2, no posts of joint director, Your Lordship, is shown here. There is no post of joint director shown here. Only deputy director, that also one post. Huge discrepancy between the two wings. And then number 2, principal senior grade, there is one post shown. But even this post, as the facts will show, reflect, these posts, against these posts, none of the petitioners' wing was ever promoted. This is senior principal. This is also, it falls under the grade of deputy director. Deputy director and principal senior grade, they fall under the same, they are of the same grade. So, though there is a vacancy shown here, none of the petitioners' wing has ever been promoted to this post. And whatever posts were available, all were being occupied by the employment wing. Now, P, junior grade, that is principal, 1 post is shown, 1, 2. 1 permanent, 1 temporary, and a total 2. So the discrepancy is, though there are 2 equivalent wings, clear discrepancies are shown in the schedules, Your Lordship. There should
So wait, your point is that if you come back to page 66.
Yes.
Okay. Now in page 66, this is the constitution of the service.
Yes.
But in the constitution, I'm just making it clear.
Yes,
Are
yes.
we clear? I'm just a
Yes,
bit
yes, yes,
curious.
Your Lordship.
Now, in the constitution of service, you're saying that for the craftsman training wing.
Yes.
Okay. There is a post for joint director,
Yes.
deputy director, etc.
Yes, etc.
But in the schedule,
it
has not been mentioned.
has
So
been
that's your
mentioned.
point.
Yes.
Okay.
Number 1. And not only that, the number of posts assigned, deputy director downwards, it should be at least equivalent to each other.
Then
That
what
is my
about
stand.
then what about
Yes.
this schedule 2A?
Now, schedule 2A.
Page 77.
Yes, schedule 2A, I am aggrieved by director, the post of director number 1. Schedule 2A talks about the employment wing, here, director. Now, this is where I am aggrieved with.
Okay.
The post, if Your Lordship will go to the eligibility and other conditions for promotion, the post shall be filled by selection from amongst confirmed officers mentioned under Rule 3A1A. Rule 3A1A means employment wing only.
Okay.
Employment wing alone has the right to be promoted to the post of director. This is what I am agreed with, Your Lordship. Provided that the officer has completed qualifying and continuous service of 5 years in that grade. So there is no scope, no chance at all for the other wing, that is the petitioner's wing, craftsman training wing, to ever reach the post of director. So I am aggrieved by this. And if Your Lordship will go to the Schedule 2B training wing, they show the post of joint director here. So this is the discrepancy. Whereas in the number of posts assigned, no post of joint director is shown in respect of the craftsman training. But whereas under Schedule 2B training wing, they are showing joint director, that there is a post of joint director available. But see, qualification for director.
Yes, so
nothing is
what are the
mentioned about.
qualifications?
So,
No, what are the qualifications required to be recruited under the employment wing and the craftsman training wing? Is there a difference?
there are two entry points, Your Lordship. One is the if Your Lordship will go to Schedule 1A, Schedule 1A, the first feeder grade is the employment officer. Employment officer, that is Class 2, Nagaland Subordinate Services Class 2, employment officers. And in respect of the Nagaland Craftsman Training Service, it is vice principal. These are equivalent posts. The vice principal and the employment officer are equivalent posts. So they are, recruitment is done through the NPSC. These two posts are equivalent. And the next entry point is the technical assistant. And the equivalent service under the craftsman training is the group instructor, foreman, so on. These are equivalent posts to the technical assistant, Your Lordship. So entry, with regard to entry also, to the NPSC examination, the pay grade is same, everything is same, only that designation is different. But in the case of the craftsman training wing, it is the engineers alone who are recruited. This being a technical wing.
Where are these posts are, this deputy director and what is this? Assistant director.
Yes.
Both the wings, is it a separate cadre or different cadre?
Assistant and deputy.
No, both these wings.
Both these wings, these are two separate wings. The
Wings
only thing is,
wings, we understand.
Yes.
Cadre. It's a separate cadre or
cadre
same
also
cadre?
separate. Only
How?
they are to meet.
Why you are saying it's a separate cadre?
No, the system is such. One is the training wing. Because
It's
of that,
wing
yes.
is wing, we understand.
Yes.
But cadre, we're asking, it's a
When
separate
it
cadre or it's a same cadre?
You're,
I think you have to show, forget about the wings, we understood.
yes, Your Lordship.
Cadre you have to show. If it's a
Yes.
same cadre, I think privacy, you have a case. If no, you don't have a case. If it's a separate cadre, you may have.
This is a separate cadre, Your Lordship.
So us
Separate
from where?
from the.
We could only see the wings.
Yes,
not the cadre.
I'll take your Lordship to the facts, background facts, how these two were amalgamated. Initially, these two were under different departments.
No,
But-
that's why we just wanted to
Yes,
know
yes, but only
whether this
subsequently.
is separate cadre
Yes.
or same cadre.
From the facts itself, from the record itself, it will emerge. From the record itself, it will emerge. These are two completely separate cutters, Your Lordship. Completely
Not-
separate
not
cutters.
the
but
facts.
They will merge. Your Lordship, I'll take Your Lordship to the facts now. The
So if he's admitting that it if he's see, if you're admitting that this is they are separate cadres,
yes, Your Lordship.
then I think you will not have a case in that case.
No, Your
If
Lordship.
it is the same cadre, then you are viling for a post, which you said equal, you should have equal chance if it's in the same cadre. But if it
Your
is a
Lordship.
separate cadre, then how can you fight for
These
a
are-
cadre, a post which belongs to another cadre?
Their entry into the service is from two streams, Your Lordship. Two different streams, but equivalent. They have been made equivalent by the service rules.
But they're
But
covered
their
by the same
entry into the
rules.
service,
But they're covered by the same rules. No.
their entry into the service has been made by way of two different streams. One falls under the engineering, the craftsman training wing is purely technical. That is why when it comes to the higher officers,
Yes, yes.
it is engineers
Nobody
only who
appoints.
are eligible. Engineers alone who are eligible. Whereas in employment wing, graduate and above, normal. No distinction. Even engineers may also apply under that. It is a general category. But under the craftsman training wing, since it is purely engineering in nature, only engineering graduates are eligible for inducting into the service. So the exam which is conducted, though they are equivalent, the posts are equivalent, but the exams that are conducted is different. The engineers, since it is technical, only technically qualified persons can appear in the exam and they are
The only
selected.
thing is, here, both of them, yeah? Joint director.
66. Institution there is a post.
Okay. Now, this is a very technical issue
Yes, Your Worship.
which needs to be thoroughly studied by both. And having heard your submissions, we feel that this writ petition deserves to be admitted. Okay? We'll admit it and fix it for full hearing some other day.
All right.
Isn't it?
No.
So that why the state respondents also will have a case, definitely, in this matter. So I think it deserves to be heard fully.
Correct.
Your Lordship.
Okay, instead of at the admission state, but it appears that there is some thing where the rules may need to be looked into or may not, but we'll have a full hearing in this matter.
Your Lordship.
Yes, this is item number. 6 to 8. What is 8? Same?
Same, analogous matter, my lord.
Analogous, they are connected matters, Your Lordship.
Heard Mr. Tongpok
Yes, Your Lordship.
Tonggegat, learned counsel for the petitioner, along with Mr.
Mr. Ajo, my lord.
Ezo, learned
Private respondents,
counsel
Five.
for the private respondents, number
5 to 16.
5 to 16.
Yes, ma'am.
And anyone else?
Government.
Yes, and Ms. Shuri, learned government advocate for respondents number 1 to 4.
Correct.
Having heard the submissions made by the learned counsels, this court finds that the writ petition has merit and is admitted. List this matter for hearing in the usual course.
Lord.
Yes.
My lord, if this matter can take next week, then next week.
Okay, next week, but as pointed out by my brother,
My lord.
here a rule is challenged.
Yes.
So in that case, notice will have to go to the Advocate General or the state government advocate can take the necessary steps. Yes, yes.
She's appearing, ma'am.
Okay, appearing on behalf of additional AG. Fine. Yes, so list the matter for hearing in usual course.
Usual. Lordship,
Yes,
there is
you
some-
want what?
My-
You
my
want
lord,
something else?
If that is so, I have a small prayer, my lord.
Yes.
I am the respondent number 5.
Huh?
In the case of petitioner, petition number 1 was sitting as joint director. I am also joint director as I'm in employment wing. But now petition number 1 resigned. He is no more in the case now. So therefore, now I'm the only senior joint director in the department, in the directorate. So since there is a stay order earlier, if not to promote to the post of additional director, so now there is no contention against me now. There is no joint director from either side. Only me, I'm the only one joint director. If this is going to be
The
heard,
other joint director
Yes.
has resigned.
yes, if
Huh.
this is going to be heard in usual course, then at least that interim may be vacant. That will do justice to both parties. Because
No.
as I said, from both sides, there is no other joint director except me, my lord.
No, Your Lordship, what happen if the interim order is
Okay,
vacated?
we'll fix a date then.
Yes, Your Lordship.
Okay, for hearing.
Yes.
Unnecessary stay continues because when there is no other joint director, but by this interim order,
Are you due for promotion now?
correct, correct.
Yes.
You're due for
Correct,
promotion?
that's what- that is
For how
what.
many years have you served as
I
a
have,
joint director?
as per the service rule, I'm entitled, I'm eligible now. I have come to the zone of constitution.
Okay, well,
And
you
for
are the
the-
deputy director.
Yeah,
I am the
Deputy
deputy
Director
director,
and-
but it so
and
happens
principal.
if the interim order is vacated, the other deputy directors who are junior to me from the other wing will now supersede me to the post
My
of
lord, in the
additional
To the
director.
post of what?
Additional director. There is one additional
They can't
director,
jump
it
to
is not
additional
here.
director, to post of additional director.
They have somehow created the post. Every now and then, they will
You
create
have to
the
be a
post.
joint director
Correct,
first,
first.
isn't it?
Yes, Your
So if
Lordship.
you are the deputy director and the
Yes.
joint director is promoted to the post of director,
Additional
then,
director.
yes, additional director first, then there will be 2 vacant posts of the joint
Yes,
director.
yes.
And then you will have a chance to be promoted, isn't it?
To the
Even
post of
if I
joint
am
Along
director.
with the other deputy directors.
Yes, Your Lordship, along with the other deputy directors, if I am promoted to joint director, for example, again,
can-
immediately thereafter, the vacancy has to be filled. Now, the rule
Okay,
rule
we'll fix
does
a short
not allow
date
me
and
to be
we'll
promoted.
We'll hear on this matter.
This is
also
the
in next
position.
date, okay? List this matter for hearing after 2 weeks.
My lord.
Or you want a date on? You give me a date then.
Yeah, because of the stay order, there is urgency because there is no additional director now.
Okay. List this
I'm due for
matter-
promotion.
List this matter on
I don't mind adjourning, but at least stay, if that can be considered.
Okay, wait, we will record this thing. List this matter for hearing in the usual course. List this matter for hearing after 2 weeks. Okay. Since the learned counsel for the respondent mentions that since the petitioner number 1 has retired, is it?
Correct,
Yes.
already resigned,
No,
Has resigned.
Retired. On
He's resigned. He
Yes,
resigned
yes,
or
yes,
he
yes.
retired.
Resigned.
voluntary retirement. Voluntary
Okay.
retirement. Yes.
Okay, he has taken voluntary retirement.
Yes.
The contention for the post of additional director can be made only by the
Prior respondent number 5.
respondent number 5, who is from the employment wing. And that if the stay order passed by this court earlier is not vacated, he would be suffering. His promotion, which he feels is due, would be delayed. Having heard the submission made by the learned counsel, this court find it fit that that the submissions made by the learned counsel for the respondent may be considered in the next court date. Fix when. Can we make it 10th May?
No, okay.
Or it can be even earlier. isn't
Earlier,
it?
my lord. Earlier
Third,
date will be.
third.
Third.
Third is Wednesday, isn't it?
Third.
Yes. 3rd, 5, 2023. In the hearing list. Yes. Okay.
Major.
Then when it's listed for hearing, you can make the submission also, since it's
Yes.
going to be heard.
Yes.
Since the interim is to be continued, your lordship may also continue the interim.
There's no one from that side to become joint director even.
Yes, leave it at that. Okay.
Much obliged.
For admission, item number 9.
9 and 10, it's small, all is the same, isn't it? 9, 10, we have, for 10, which is again the Pradhan Mantri Garib, whatever. So 9, in 9 what?
Yes.
Please, your lordship.
Yes.
Lordship, for item number 9, this is
Okay,
with
the
regard to the
petitioners,
PNG.
you're representing different petitioners, is it? Yes. Number
Same
9?
petitioners, but different issues.
Okay,
For item number 9, we're seeking for proper implementation, lordship.
yes. So what has the state respondent has given this big file, is it the implementation report?
Lordship, this PIL is the regard with the Pradhan Mantri
Yes, yes.
PMGKY. It is a COVID-19 pandemic scheme. So that pandemic scheme has already been stopped. And on the last occasion, I have intimated to this court and the petitioner the seek time to take a proper instruction whether that
Yes.
has been stopped or not. Until now, also they are not.
But what is this? What is this?
That
big
is,
thing?
they are alleging that those persons are not getting the scheme prices per month. But these are the records to show that they are getting the scheme regularly, Lordship.
So this is a
Lordship,
report filed by the state respondent,
Lordship.
showing that they are getting the,
Yes.
with all the
The
signatures.
beneficiary,
Lordship,
yes.
if I may make a
Beneficiaries,
small
yes.
brief submission, lordship.
Uh,
Lordship, initially this scheme was introduced by the union government to against the backdrop of COVID-19 to ameliorate
Rice
the
and
suffering.
grains.
Yes.
Oh.
So this scheme provides 5 kg additional rice grains to in addition to the uh, scheme which is provided under the National Food Security Act.
Oh.
So now, Lordship, this scheme was rolled out phase-wise. So it was rolled out in April 2020, and it has been extended till December last year. Now, Lordship, in the recent budget session, there has been a development, Lordship. The scheme has extended for another 1 year. Lordship, unfortunately, I'm unable to procure the order of the government. But Lordship, I have the newspaper clippings.
Newspaper clippings will not do.
Lordship.
Okay, because
Lordship.
newspaper, they can sometimes be a bit misguided also.
Yes,
So
Lordship, but
you get the required extension, because as per the affidavit which has been filed by the state respondent, it says that has been the what? Rice and pulses,
Yes,
I think,
Lordship.
has been supplied during which month this is?
From April 2020 to
For the year
yes,
2020 to 2021, is it?
yes.
This is that it has been a big thing, okay, with signatures.
yes, Lordship, we've received.
2020 to 2021, they said
Lordship,
they have complied.
Yes, yes. I have
Okay.
no objection to that,
So you're
Lordship.
saying that now it's been extended for another 1 year,
Yes,
that is
Lordship.
2022.
No, Your Lordship, it has been closed with effect from
That's what-
January 2023.
Lordship, in the recent budget session, there has been an
Okay, so
extension.
let him get that, let's find out.
Otherwise,
Yes.
He doesn't
unnecessary
have
keeping
anything
the
writing.
PIL, Your
Lordship,
Lordship, pending. Your
Since
Lordship,
I'm satisfied with the reply filed by the
Yes. You
filed,
have checked, huh?
by the state government,
Huh.
my only prayer, humble prayer, is that if this honorable court can pass a direction for proper implementation, as long as this scheme is
when the
continuing.
scheme is closed, where is the question of proper implementation, Your
So
Lordship?
it has been implemented.
Yes,
isn't
we had
it?
already
You're
implemented.
As far
satisfied
as
that
far as
it
the
has been
list is
implemented?
concerned, Your Lordship.
Yes. So we'll close the PIL.
Yes, we
If
can
you find
close
that
it,
there's
Your Lordship.
something new which
Yes.
has not been done by the state respondents, then
Yes,
file
Lordship,
afresh.
we can close the PIL.
Yes, yes.
But my humble prayer is for direction, Lordship, proper
No, what
implementation,
will I direct?
because it has been extended, Lordship, as I said.
That you have to show.
Okay, then
So
Lordship may
this,
kindly
as far
grant me
as your
time.
PIL is concerned,
Yes,
they have replied and they said we have complied. And they have shown this, which is from the month of May 2021, month of June,
Yes, Lordship.
the petitioners who have received it with their signature. So concerning this, it is closed. Okay?
yes, Lordship.
Now, if you find that there is some order extending that they should again receive besides this, and they have not, then you
Yes.
file another PIL
Lordship, that
if
will
you
just
find it's required. Because here, okay, let's look at your PIL.
Lordship, if
Let us.
I may
let's
be allowed
look
to
at,
read my prayer, Lordship.
let's see
Show my prayer.
portion. Where is it? Wait, no, where is it? The main petition. No? This is the state reply. Yes,
Page 9.
Page 9, Lordship.
yes. What is your prayer?
Just a simple prayer, Lordship.
Yes.
For
Number A.
prayer number A, to direct the respondent to provide 5 kg of rice wheat to every person per month for 8 months.
Okay, has that been complied with in your?
Yes,
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 A
Lordship,
has been
yes.
done. Yes. Then next.
To direct the respondent to provide 1 kg of pulses to each family per month for
So
8
you're
months.
satisfied that has been done,
Yes.
isn't it?
Lordship,
Yes.
yes.
Then.
For prayer C, to direct the respondent to provide free rice and pulses and identify who do not have ration cards.
So have you done that?
Your Lordship, everything, whatever the prayer is
It's
there,
done.
we have, yes,
Lordship,
because it's
with
a
regard to that, we
COVID-19
have not received
pandemic
any
scheme.
What?
answer from the state government.
To provide free of rice and pulses, free of rice and pulses.
The list which the state government has provided is with regard to those people who have
1
ration
kg and
cards.
5 kg, isn't it?
Yes.
Okay, and identify those who do not have a ration card. Maybe you have to identify or at least submit
Your
that there's
Lordship,
no
it is
person.
one nation, one ration card only.
Huh.
It is a nation, one ration
So
card.
you're saying that
So
as
all,
per-
yes, what the petitioner they're alleging is that in the village of Visema, Kedima, Kezoma, Kuzama, and Pesama, they did not get the monthly free rice as well as pulses. So this court has
A and B, A and B.
Yes,
isn't
so
it?
this
A
court
and
has
B.
directed, and we have filed the comprehensive
Yes,
affidavit, Lordship.
concerning A and B. Okay.
Yes.
What
Yes,
about
Lordship.
C? Now, is
C and D,
C connected with A and B?
Yes.
This free rice,
Yes.
rice and pulses. It is the rice and pulses mentioned in A and B, or another free rice and pulse. This thing you have to be
It
clear.
is only
No,
N and B,
Lordship, this
Your
is
Lordship.
we're talking about the scheme, under the scheme, which is
Under
under
the
the scheme.
scheme.
So under the scheme, they're getting
Yes.
5 kgs of rice free, okay?
Yes.
And then 1 kg of pulses free. So your point C, isn't
Yes.
it a repetition of A and B?
No, this is with regard to persons who do not have ration cards.
What's this? So are there persons not having ration card? Come to the main text of your prayer. So you're saying that it is not purely concentrating on this Garib, the scheme, but it also includes that people should be having ration card. Is it? What's your pray? I mean, how did the
Lordship, under the
PIL
scheme,
come about?
under the scheme, there are
Under
different
the
kind of.
Pradhan Mantri Garib Harao, whatever,
Yes.
everyone has to be given a ration card. Is that it?
Yes.
Where's the scheme? Copy of the scheme. Does it
Lordship,
imply?
If my lord can kindly turn to page number 19.
19.
Annexure
Yes.
3 of my
Yes.
petition.
Page number 19.
So there is a
Ah.
graph which shows.
Yes. Ration. Okay,
Yes.
given. Where does it say that ration card has to be given to every, ration card should be there? If you are concentrating only on the scheme, then the scheme does not say that everyone has to be provided with a ration card. Is it? No.
Lordship, in that case, let me provide something, Lordship, the order of this extension.
Lordship, that would be another course of action,
Just
Your Lordship.
1
because-
week, Lordship.
What do you say? See, at the time when you filed your
Yes,
BIL,
Lordship.
okay, whatever you have filed, you feel that it's been done. You agree?
Yes,
Okay?
Lordship.
So we'll close this. If there's any extension which you have to still file, and then you can come afresh.
Okay, Lordship.
Okay, at least this stage, whatever you have filed, it has been done. It's been complied with.
Yes, Lordship.
Okay, you have verified. They have
Okay,
received.
Lordship. In that case, we may close.
Yes. Okay. Yes, heard, Mr. Your good
K.
name,
Arka.
please.
K. Arka.
K. Arka. Is your name here in the,
Lordship, my name is not reflected.
why?
Lordship, I'm appearing on behalf of my
Okay, heard Mr.
senior
So-and-so.
counsel.
Appearing on behalf of his senior counsel, Mr.
Miss Nitya Koza.
Okay, Miss Nityo Koza, learned counsel for the petitioner, along with Miss Sori, learned government advocate for the
Lordship, I'm
state.
additional AG.
Okay,
Yes.
along with Miss Sori, learned additional AG for the state respondents. Mr. So-and-so for the petitioners mentioned that uh, the present PIL appears to have been complied with as per the report filed by the learned state respondents through the additional AG. However, he submits that there is an extension order
Yes.
with regards to the scheme, which he is not able to file before the court today. Ms. Sori, learned additional AG, submits that insofar as the instant PIL is concerned, the state respondents have done the needful and the prayer in the PIL has been fully complied with by the state respondents. She submits that the PIL may be closed since no further steps is required to be taken by the state respondents. Having heard the submissions made by both the parties, this court finds that since the prayer in the PIL petition has been met by the state respondents, in the documents filed along with the reply to the PIL, showing that the persons to benefit from the Pradhan Mantri Garib Kalyan Yojana scheme have all been supplied with the rice and pulses as per the scheme. And thus, we find that no further steps is required to be taken by the state respondents with respect to the instant PIL wherein the PIL was filed for supply of 3 grains during the month of April-November 2020. In view of the above, we find it fit that the instant PIL be closed, being complied with by the state respondents. Okay. Oh, full stop, closed. Now, see, in your PIL, you had mentioned that it is during this period, April
Yes.
to November 2020. So
Yes,
that's
ma'am.
done.
Yes.
If there's anything new, that's a different matter, isn't it? Yes.
My lord. Pleasure, my lord.
Much obliged.
Item number 12.
Yes.
May I please, Lordship? Lordship, may come to the order dated 9/12/2022, passed in the present date.
Yes.
Lordship, as per this order, the State Council was directed to obtain certain instruction with regard to the inquiry conducted against the respondent number 4, as well as when the select list was published.
Yes, so
May I
have you
please, Your
taken the
Lordship?
necessary
Yes,
instructions?
my lord, I'm yet to receive instruction. So kindly allow me 2 weeks' time, my lord.
Okay.
Lordship, in that case,
I'm for a private respondent here. Since enough time has been granted to the state respondent to file an instruction, Lordship, since there is stay in this case, because by the single bench, that direction has been made to the state respondent to let the private respondent join the service. That is now by the interim have been stopped. So, Lordship, in that case, interim may be heard because that interim is only up to that next returnable date only.
The IA. But isn't the IA connected with the report which we have yet to receive?
No, that is again subsequently that report, that order has been passed to the effect that report is to be filed, not by IA.
Your Worship, by the impugned order, by writ petition was dismissed. In the other writ petition filed by the present private respondent number 4, that was allowed by directing the respondent authorities to conduct an inquiry whether she belongs to the indigenous inhabitant of the state of Nagaland. So that the inquiry report is awaited now.
Okay, so if the respondent, okay, happens or is not the indigenous,
She's not entitled to appointment in the case.
then she's not. So
Yes.
how can we consider the IA when we have to verify first whether they are indigenous or not? Isn't
Lord-
it? It'll cause some friction then.
Of
the
course,
report.
of
More
course.
problem
I
with
think-
That is the crux of the case,
Mhm.
and that is the issue here.
Mhm.
And of course, later on, that this court has directed the state respondent to file instruction before this court.
So the state respondent,
the
please do the needful, isn't it? Instead of by the next court date, I think you should be able to
Worship,
get
the
the report.
instruction has to be received from
Just
Kohima
because
itself.
of delaying
By
filing
next
the
week we can
report.
take up. By next
Otherwise,
week.
see, I'm not going to press on that. But how long that?
How many, how
Yes,
many?
my lord,
huh,
my lord, by any means, within 2 weeks.
Within 2 weeks?
Yes, my lord.
You're giving us assurance?
Worship, that means the last chance.
Based on the assurance, please, you have to take the trouble to, in fact, contact the concerned department and remind them, you know.
My lord,
Don't wait for the officials to just come and give it to you, because I know how the government functions also. Okay, you have different officials, they have different things in their mind, while you have to concentrate only on the court case. So you push them, call them. I'm sure you
Yes.
must be having their phone numbers also
Yes, my lord.
of all the departments, okay, nodal officers concerned with the court cases. So in these sensitive matters, you have to be sometimes a little bit proactive, you know, isn't it? Yes. Heard Mr.
Lima Wabang, Worship.
Lima Wamang, learned counsel for the petitioner, along with Mr.
E.T. Paphom.
E. Tibapong, learned government advocate for the state respondents, and Mr. Kekar Guli,
Oh, yeah, for
okay,
respondent
learned
number
counsel for respondent number 4. It is submitted by the learned government advocate that in terms of the order of this court dated 9/12/2022, he has yet to receive instructions as to whether the respondent number 4 is a indigenous inhabitant by verifying the indigenous inhabitant certificate of the respondent number 4. Isn't it? And has prayed for time for submission of the final report. Submission of the inquiry report.
Yes, ma'am.
Okay. Mr. K. Kiraguli, learned counsel for the respondent number 4, mentions that there is urgency in this matter since he has made there's urgency in this matter due to the pendency of the
No, Lordship,
IA.
No, interim.
Lordship,
Stay.
IA is a stay order, isn't it?
Lordship, by order dated 15/3/2022, passed in the passed in the mini bill,
Passed in the
in the appeal.
main appeal due to the stay order
15/3/2022.
passed on 15/3/2022. In view of the above, the learned government advocate is to ensure that the required report is submitted by the next court date.
Lordship, interim order may be allowed to continue.
List the matter after
2 weeks,
2
ma'am.
weeks. Meanwhile, interim order passed earlier shall continue till the next date. Yes.
Much obliged.
For admission, item number 15.
Fifteen.
May please, Your Lordships. Lordships, my prayers have been answered in lieu of the order passed by the Supreme Court, Honorable Supreme Court.
Okay. So
The
we are
petition has
filing,
become infructuous.
praying for withdrawal
Lordship.
of the PIL. It has become infructuous.
Yes, Your Lordship.
Okay.
Can be disposed of.
Good heard, Mr.
K.R. Kachumi.
K. Marche Tuni, Learned Counsel for the petitioner.
K.R.
along-
Ka.
Okay, these are the names, okay, along with Mr. So-and-so, counsel for the
Respondent number 6.
respondent number 6 and Mr. So-and-so, learned government advocate. For respondent number 1. 1, 4 and 5. The counsel for the petitioner has furnished the order dated 09/12/2012.
Lordship,
Is it?
May I be-
What are the orders, huh? 09/12/2012 and 17/10/2000. No, 09/12/2022 and 17/10/2022. Is it?
Yes, that has been placed before the Honorable Court.
Okay.
Lordship, for recent judgment, may I be allowed to
Okay, and
place
there's
it before
another
this
one?
Honorable? Yes.
Huh, yes, please. What does it say? This is the same writ petition. What does the judgment say?
Lordship, initially this writ petition was filed challenging the illegal appointment of DGP Nagaland. So, Lordship, during the pendency of this case in this Honorable High Court, Lordship, different petitioners have approached the Supreme Court. So now, Supreme Court has passed the order dated 23rd January 2023, by which, Your Lordship, the incumbent DGP has been appointed, Your Lordship.
Okay. Yes, I know.
In fact,
exactly.
this
But they say it's
PL was not maintainable.
Yes. The order is 11th April 2023.
Yes.
The one which you have just submitted?
Yes.
The 11th April 2023 is the one.
Lordship, the recent order is dated January 23,
But
2023.
there's more recent one. This what you have given us a copy is 11 April 2023, even more recent. Okay, what you have given us
Lordship,
is-
that is listed
Okay, yes.
It shows
List of
listed for
petition on
11.
so-and-so. So, yes, 23rd January 2023.
Yes,
Yes.
Lordship.
So now you're saying that DGP has been appointed
Yes, Lordship.
and it is Rupin Sharma?
Yes, yes.
Okay. But Mr. So-and-so, learned counsel, okay. The learned counsel for the petitioner has submitted the order passed by the Honorable Supreme Court dated 23rd January 2023, wherein it shows that the name of Mr. Rupin Sharma has been empaneled for the post of DGP, and that the state has been directed to pass the consequential orders within a period of 1 week for appointment of the officer who has been duly empaneled by the UPC for the post of DGP Nagaland. Where's the order?
Yes, consequent to this order, Your Lordship, the state government has appointed.
So where's the appointment order? You should have also submitted that. Okay? The learned counsel for the,
Lordship, the present incumbent, the DGP Rupin Sharma, is appointed on order dated 4th
okay.
February
The learned
2023.
government advocate also mentions that Mr. Rupin Sharma was appointed by the state government.
By notification dated 4th February 2023.
White notification dated
4th February
February
2023.
2023. You should be having the notification before the court so that we can place it on
Unfortunately, I don't have
record,
it.
isn't it? In view of the above, it is found that the instant PIL is now found to be infructuous or has been compiled with. Okay, has been compiled with, and therefore the PIL 6 of 2022 stands disposed, closed and disposed.
Right, Your Lordship.
I think, wait, you submit a copy of the appointment order and put it in file. Okay, that should be the appropriate step to be taken. Yes.
For admission, item number 17.
Your Leadership, my Lord, I was the respondent number 8 in the writ petition.
Yes.
And in the writ petition, the date of my date of entry into service and my seniority vis-a-vis the respondent number 1, that was the issue in the writ petition. And the Honorable Single Judge decided against me, and therefore now I am here before your Lordships by filing this writ appeal. Now there is a document in this writ appeal, Your Lordship, and it is at page 217. Page 217. And this document precisely explains what this case is all about. If your Lordships can come to page 217.
$217, 17 or 70?
217. 217.
Yes.
207, 17, and may I read? My Lords, may I read? 217. Urban Development Department, this is the department concerned, has referred the matter of seniority between Srimati Timjan Renla, that is the appellant, Assistant Director, redesignated from Assistant to Assistant Town Planner and Assistant Architect, and Shri Pangjong Kokba, Assistant Urban Development Officer. The department has not explained whether they are in the same. Lordship, there's a typed copy. There's a separate bundle of typed documents. And
Yes, where's it?
no, it's not yours. Is it there?
Type documents.
Okay. Right
No, Your
documents
Lordship,
index.
this document has not been typed. I'm sorry, my lords. May I continue from here?
Yes, okay.
217. We can go to the next page straight away, Your Lordship. It's much more clear page. It continues to the next page. 218. The issue on the examination concerns: 1. Representation on claim of seniority from Shri Pangzang Kokba, Assistant Town Planner, for the period of service rendered on contract service on the basis of and in the ratio of 3:1 as was notified by the government. And number 2, representation on claim of seniority from 1 Srimati Timjanila Kechu, Assistant Director, over Shri Tarachu, Assistant Director. So Timjanila Kechu, that is the appellant in this case, Your Lordships, and Shri Tarachu Fitu is the respondent number 1 in this writ appeal. Insofar as one above is concerned, the Honorable Gauhati High Court has quashed the said government notification and communicated by Office of the Advocate General, copy attached. We may therefore communicate our regret on the request. As regard representations at 2 above, the following case note background may please be seen. Copy of contested tentative signature list attached, flag B. Background of creation of the post of Assistant Architect. Lone post of Assistant Architect, Class 1 Gazetted, was created by the Urban Development Department, hitherto under administrative control of the Planning and Coordination Department, wide number such and such, dated 9/5/90, copy placed at page 23. Initially, one Shri Chenitung Lotha was appointed against this post and appropriately posted to the office of the Chief Town Planner, now Director Urban Development, white page such and such. The said Shri Chenitung was subsequently appointed as Assistant Town Planner by a cabinet decision white order dated at page 81. Consequent upon appointment of Shri Chenitung as Assistant Town Planner, requisition for recruitment to the post vacated Assistant Architect was accordingly initiated by the Planning Department to the NPSC. Your Lordships may kindly note this sentence. The post vacated Assistant Architect was accordingly initiated by the Planning Department. Your Lordships may kindly also note the department concerned. Planning Department to the NPSC, white dated 8/6/98, white page 3C. NPSC was perhaps, now this is where a thorough consideration has been taken by the Department of PNAR. Your Lordships are aware the Department of PNAR is the nodal department as far as service matters are concerned in government service. So NPSC was perhaps of the view that the post of Assistant Architect created by Planning Department also falls under the purview of amalgamation of all the engineering wings under the administrative control of Works and Housing, and thus advised the department to route the requisition through Work and Housing as per the letter dated at 5C. Planning Department accordingly endorsed the requisition to the Works and Housing Department by letter at NPC, subsequently conducted the examination, and Srimati Timjanula was selected and formal appointment order was issued by the Works and Housing Department at page 6C. Now, if we may pause here for a moment, Your Lordships. In the year 1998, the government took a decision to amalgamate all engineering wings under various departments into the Department of Works and Housing. 1998. My Lords may kindly note the year, 1998. After the amalgamation of the engineering wings under the Department of Works and Housing, insofar as the Planning and Coordination Department is concerned, now, Lordship, the Planning and Coordination Department looked after town and country planning. So in the Town and Country Planning Department, the services of an architect was absolutely essential. So after the amalgamation in the year 1998, one single post of Assistant Architect was created exclusively for the Department of Planning. Lordships, we kindly see that order at page 301. Before we come back to this again, Lordships, page 301. at page 301. And this is a letter dated 9th May 1990. 9th May 1990. For quick reference, Your Lordship, the amalgamation order is at page 10, at page 74, page 174. Just for the dates, my lords. At page 174. It is there in the typed copy bunch, Your Lordships. At page 10 of the typed copy.
174.
174. Typed copies in a separate set, Your Lordships. And it is at page 10.
Okay. Yes.
Page 10. And Your Lordships, may kindly note, just read the first paragraph, Your Lordships. This is a notification dated 18 January 89. 18 January 89. It reads, consequent upon the amalgamation of all engineering wings attached to various government departments in the state, except those of the departments of NST, Geology and Mining, Agriculture, inclusive of irrigation, into one department, namely the Works and Housing Department, by government notification dated 6/12/88. So the actual notification of amalgamation is 6/12/88. The Governor of Nagaland is pleased to order the division of bifurcation of the Works and Housing into two wings, namely the Roads and Bridges and the other as the housing, each under a separate chief engineer with effect from 1/4/89 as indicated below. Then Your Lordships will see, one is Chief Engineer Roads and Bridges and two is Chief Engineer Housing. Now, if Your Lordships may come further down the page and come to A, capital A, placement, designation of engineers and the housing wing. And Your Lordships will see at the bottom of the page, architect, assistant architect. Have Your Lordships noted that? Assistant architect and architect. So at that point of time, in the year 1989, there was one post of architect and two posts of architects. So these posts, assistant architects, these posts were amalgamated with the Department of Works and Housing and placed under the Chief Engineer Housing. So after this, my lords, after this, considering the need of the planning department to have an architect for its own use, this single post of assistant architect was created, which is at page 301. In the typed compilation, Your Lordships will find it at page 43. Page 43 of the typed compilation.
Yes.
May I read, my lords? This is dated 9th May 1990. So this is much after the amalgamation. And it is addressed to the Chief Town Planner, Government of Nagaland, Planning and Coordination Department, and it is addressed to the Chief Town Planner. Subject, creation of additional posts, gazetted and non-gazetted, class 1, 2, 3, and 4, under Town Planning Department. Your Lordships may also note the department concerned. It is Town Planning Department. It is not Works and Housing Department, Your Lordships. Town Planning Department. Sir, I am directed to refer to your letter dated 5/1/89 on the subject cited above, and to convey the sanction of the Governor of Nagaland to the creation of one post of Assistant Architect, Class 1 gazetted, under the Town Planning Department. Again, Your Lordships may note, under the Town Planning Department, in the scale of pay shown as per annexure enclosed, plus all other allowances as are admissible under rules from time to time in Nagaland with immediate effect. The expenditure is debitable to the head of accounts such and such. This is planned expenditure. This issues with the concurrence of the Finance Department right there, dated 26/4/1990. So there is no ambiguity insofar as this letter is concerned, Your Lordships. It is clear, it is crystal clear that a post of Assistant Architect was created for the Department of Town Planning, not for the Works and Housing Department. However, Your Lordship, now if you may come back to the note which I was reading earlier at page 218. 218. May I continue reading again, Your Lordship, from paragraph 2. Page 218.
218. Yes.
From paragraph 2 again, my lords. Consequent upon appointment of Sri Chenithong as Assistant Town Planner, requisition for recruitment to the post vacated Assistant Architect was accordingly initiated by the Planning Department, dated 8/6/98. NPC was perhaps of the view that the post of Assistant Architect created by Planning Department also falls under the purview of amalgamation of all engineering wings under the administrative control of works and housing, and thus advised the department to route the requisition through work and housing as per the letter at page 5. Planning Department accordingly endorsed the requisition of the Work and Housing Department by letter at page 5. NPAC subsequently conducted the examination interview, and Srimati Tim Janandla was selected, and formal appointment order issued by the Works and Housing Department at page 6. This is where the mistake began, Your Lordships. I was born in the Department of Town Planning, but on the mistaken understanding of the NPSC, the requisition which was sent by my department was routed through the Works and Housing Department, and on my being successful, my appointment order was issued by the Department of Works and Housing. May I continue reading, my lords? It may be pertinent to point out that a post of Assistant Architect was created by the Planning Department after amalgamation was notified, and thus the said post of Assistant Architect do not find place in the list of amalgamated categories of posts, nor had the Works and Housing initiated any addendum to incorporate and brings to its administrative control this post in question on the strength of government notification of amalgamation till date. Hence, the post of Assistant Architect under Urban Development Department is free from the said amalgamation and is a regular cutter post of Urban Development Department. It may also be noted that the appointment orders, though issued by the Works and Housing Department in respect of Sri Chenithong Lotha, and so Chenithong Lotha was the previous person who was appointed to this post in Lordship, and Srimati Tim Janandla against the post of the said post of Assistant Architect, the officers were posted to the office of the Chief Town Planner at paragraph 4 of page 6 and not deputed. So though the appointment orders were issued by the Department of Works and Housing, my predecessor, Chenithong, he was posted in the office of the Chief Town Planner. I was also posted in the office of the Chief Town Planner. Therefore, the contention that incumbent posted to the department against the post created by the said and same department cannot be considered as on deputation. It may also be pertinent to point out that during the study leave period of Srimati Tim Janandla Kechu for undergoing postgraduate course in MURP, one Sri Taracha Fitu, so this is the respondent number 1, my lords, was appointed temporarily as Assistant Architect against the study leave vacancy by the Planning Department. So in the respondent number one's case, when I went on study leave, he was appointed against the study leave vacancy, and the order was issued by the Planning Department, not by the Works and Housing Department. And your lordships may find that at page 310. Page 310.
So you're unhappy with this?
I am not unhappy, my lords.
Then?
What has happened here is that the respondent number 1 has claimed that since I was appointed by the Works and Housing Department, I cannot claim entry into service ahead of him in the Department of Urban Development Department. I'm coming to that, my lords. It's all reflected in this note as we progress further down, your lordships. So, but if your lordships may kindly turn to this page, 310. So all along, the argument has been advanced that my appointment orders were all issued by the Works and Housing Department. But insofar as the Assistant Architect post is concerned, the post which I was holding, from which post I went on study leave, the respondent number 4 was appointed against study leave vacancy by the Planning Department, not by the Works and Housing Department. That is what I'd like to show your lordships. This is at page 310. Got it?
Okay, 310 is what, town planning?
Yes, by the Planning and
Department.
Coordination Department. May I read, my lords? This is dated 24th August 2001. In the interest of public service, the Governor of Nagaland is pleased to appoint Sri Taracha Fitu, which is the respondent number 1 in this writ appeal, as Assistant Architect under the Town Planning Department on contract for a period of such and such, in the scale P of such and such, and all other allowances as are admissible from time to time with immediate effect. The appointment is made against the study leave vacancy caused by Srimati Tim Janandla Kechu, Assistant Architect under Town Planning Department, and that the appointment of Shri Tarachu Fitu will stand terminated as and when Srimati Temjanandala Kechu is reverted back. Now, the point here, my lords, is that this appointment order against my study leave vacancy is by the planning department, not by the works and housing department. So I was appointed by the works and housing department, an order issued by the works and housing department. Let me put it that way, my lords, by an order issued by the works and housing department. Against the post which I vacated while I was studying, against the study leave vacancy, the respondent number 1 was appointed by the planning department, which is my department, not by the works and housing department. Then may I continue, my lords? Back to page 219. Against the study leave vacancy by the planning department and not by works and housing department, copy attached as flag C. The post duly created by the urban development department and the services of the incumbent against the post being utilized since its creation in 1990 by the department, and thus the term deputation as contested by some officers does not arise then and now, and the post falls under the regular cadre strength of the department. Then, comparative statement of pay structure of assistant architect and assistant town planner. Name of post, assistant architect, scale, such and such, year of ROP, such and such. And assistant town planner, 930, such and such. Now, may I continue, my lords?
Yes.
Below that?
Yes.
From the above table, the following can be seen. Till ROP 2004 came into force, the post of assistant architect carried higher scale of pay and status. It was only in ROP 2004 the post of assistant town planner was equated with that of assistant architect in terms of scale, pay, and status. This is also important, your lordships. Till ROP 2004 came into force, the post of assistant architect carried higher scale of pay and status. It was only in ROP 2004 the post of assistant architect, assistant town planner was equated with that of assistant architect in terms of pay, scale, and status. Which means, my lords, till 2004, the post of assistant architect had a higher pay and status in relation to the post of assistant town planner until the year 2004. B, till ROP 2004 came into force, the incumbent against the corresponding post of assistant architect enjoy higher scale of pay and status than that of assistant town planner. B, educational qualification prescribed for assistant town planner and assistant architect. Assistant town planner, as per Service Rule 1978, as amended in 1991, any of the following: degree in architecture, degree in civil engineering, postgraduate in geography, economics, sociology, with postgraduate diploma in town planning. As per revised rules of 2004, any of the following: degree in architecture with postgraduate in town planning, degree in civil engineering with postgraduate in town planning, postgraduate in geography, economics, sociology with postgraduate in town planning. Assistant architect, degree in architecture. As can be seen from above, prescribed education qualification incorporated in Service Rule 1978 as amended in 1991, which is followed. This is also important, your lordships. The amended rules of 1991, though in the draft stage, it has all along been followed by the department. Is followed in letter and spirit in determining all service matters and cadre managements for the purpose of appointment to the post of assistant town planner. Possessing of MURP is not mandatory. So, your lordships, till 2004, the possession of the postgraduate degree in architecture was not necessary. This MURP degree became an essential qualification only in the rules of 2004, not before. It's not mandatory. Possessing of MURP is made mandatory only in the recent revised Service Rules 2004, which came into force only in 2007 on approval of the Cabinet, as is authenticated and remarked by departments dated 1/7/2007. Service profile.
Can you just cut short your points first?
Yes.
Since this matter is only for admission hearing,
Yes, my lords.
if you can just give us a more brief gist as to why you have come to this court.
So
And then if you find some merit as to why we have come, then we will admit to your this thing case,
My lords.
isn't it?
My lords,
What is wrong with the,
that is why, my lords.
what is wrong with
Your
the
Lordships,
judgment of the
this-
lower court that you have come? And if we find that there is some merit as to why you want to file an appeal,
I was appointed.
then we will
Yeah, okay.
admit your appeal.
Very well,
If
my
we
lords.
find there is some merit.
Very
So
well, my
can you just make it a little bit short instead of the extensive hearing? Because I don't think we can dispose it off at this admission stage.
I agree, my lords.
Uh-huh.
But if this is just about
What is wrong with the
2 or 3 more
judgment?
pages, 2 or 3 more pages. But let me try and be brief then.
Points, yes, just can you be a bit more brief?
So I was appointed as an assistant architect
Yes.
through the selection process in the year 2000.
2000,
2000.
yes.
The respondent number 1 was appointed as an assistant town planner in the year 2004.
Okay. 2004.
Yes.
Okay.
Now, in the rules of 1991, there is no promotional post for assistant architect. There is no promotional post for assistant architect. The feeder post for promotion to further grades in terms of the rules is the assistant town planner.
Okay.
Assistant town planner.
Oh.
So I submitted a representation saying that some promotional avenues should be provided for me. So in the year 2006, the government took a decision to redesignate the post of assistant architect to assistant town planner.
Redesignate.
Yes.
Simply redesignate.
Yes.
Without any benefits, is it?
Redesignate, your lordships.
Okay.
It's just one post becoming another post,
Oh.
or 2 posts becoming 1. It's a merger of posts in the manner of speaking, your lordships.
Okay, so the assistant
merger.
town planner has.
Assistant
this
architect became assistant town planner.
thing.
The 2 posts merged
Yes.
into 1. Because of that, seniority issues arose. Seniority issues arose. It came to be decided by this note issued by the Department of PNAR, a detailed and thorough exposition of the case between the appellant and the respondent number 1. On the basis of this note, a seniority list was published in the year 2010.
Okay.
So that seniority list, where I was placed higher than him, that was challenged. In the meantime, the government brought in the rules of 2004.
Okay.
Now, in the rules of 2004, the post of assistant architect, which was redesignated as assistant town planner, from its creation till its redesignation, is included in the rules of 2004.
Okay.
So initially, what the petitioners did, they challenged the rules. They challenged the rules of 2004. During the course of the proceedings before the Honorable Court in the division bench, the petitioners came to the understanding that it is a prerogative of the government as far as creation of posts is concerned. So the challenge to the rules was withdrawn.
Okay, 2004 rules.
Yes, which came into
Challenge
effect in the year
was withdrawn.
2007.
Oh.
So the challenge to the rules was withdrawn. So my case was this: with the challenge to the rules withdrawn, which means with the redesignation of the post creation itself, which is also noted in the rules, and the redesignation which forms a part of the rule itself. Once the challenge to the rules is withdrawn, the case itself goes, the case filing petitioner goes. However, your lordships, on the ground, ignoring the decision of the Department of PNAR, ignoring the rules, the Honorable Single Judge has come to the conclusion that I was appointed by the Department of Works and Housing. And therefore, I entered into the department only when my post was redesignated and brought into the Department of Urban Development Department, 2006.
Okay.
That is the case, my lords. That is the case. So my case
While
is...
yours is, while your case is that it's simply the nomenclature that has been changed,
Yes.
and you were there all
Yes,
along.
yes.
Okay. While the single judge decided that you were appointed on the date when the nomenclature was changed.
Yes.
Is it? That's your
yes.
point. huh?
And that I was appointed by the Department of Works and Housing.
Okay. Okay. Uh-huh.
And that the engineering service rules applies to me. Now, your lordships, in the service rules, the engineering service rules, the post of assistant architect, the post is a 100% promotional post. There is no direct recruitment as far as assistant architect is concerned. So that's why I'm here before the Honorable Court in writ appeal, your lordships.
Okay. Do we find merit in this appeal? Can we let me?
It will require a very lengthy hearing, my lords. Yes.
Yes, it will be a full hearing on this
Yes, my lord.
matter. Because without hearing the respondents, it might not be as simple as you so mentioned. But having heard that, anything you want like to mention?
If this lordship wants to admit it, I have no objection. But if lordship wants to grant an interim order, I have certain things to say.
I have filed an application in lordships, but I'm not
Okay,
pressing that.
We're not
Just a
pressing
date.
on that.
Just a date
So-
may be fixed after
Okay,
admission.
so we'll admit the appeal, then I think the matter deserves full hearing. And the
But
hearing
lordship,
rests.
I have two
Yes.
preliminary objections. If
Yes.
your lordship may,
Yes,
in my-
yes.
if my learned friend allows me. Lordship, my first objection is that in the writ appeal,
Mhm.
a new course of action has arisen after the passage of the
Okay,
single bench
judgment.
order.
Uh-huh.
A new seniority list has been published,
Okay.
and the same seniority list has been challenged in this writ appeal. And to my submission, my humble submission before lordship is that this is a new course of action, and therefore it has to be challenged by way of a writ petition, not in this present appeal, because the new order notification is
In the new seniority list.
Yes.
Okay, the new
The position has
seniority list, it is there. Has the position changed?
Yes,
or no?
lordship, I've been made
That's
senior.
changed.
You have been
Senior.
made senior.
Yes, as per the
But
judgment of the single
in the
bench.
court of the single judge,
Yes,
okay, you were made what?
I was mid junior to
Yes.
third.
Junior.
The single
That
judge,
was challenged, and that has been quashed by the learned single judge. So the
So if it has been quashed,
yes.
that means you were still senior,
Now as of now, I'm the senior.
senior. And as per the judgment of the single judge, you were placed more senior or
Senior.
junior?
Senior. Senior.
So it's the same, the matter is the
Yes.
same.
The
Yes.
only thing is, the only objection I'm placing before lordship is that the
The issue is
notification.
the same. See, but the issue is the same.
Yes.
Now, you have been made senior by the single judge.
Yes.
He's unhappy with that. Now, maybe based on the judgment of the single
Yes.
judge, a new seniority list
Yes,
has
yes,
been
yes.
made. That
That's
has
what.
been appealed against. So I think
What
the
I'm
issue
saying
is
is,
the
it
same.
has been challenged in the present writ at this appellate stage. It was not a part of the writ proceeding, lordship.
But the decision of the government in making you more senior,
I'm not
Okay.
against that, lordship.
you're not against that.
Yes, lordship.
And the single judge has also upheld your seniority.
Yes, lordship.
Isn't it?
Yes, lord.
So he has a right to challenge that if he wishes on whatever grounds, because the government must have considered the judgment of the single judge. Based on that, it is
yes.
because
True,
on what
lordship.
grounds have you been placed more senior?
Yes.
Must be on the same grounds which was taken by the single judge.
Lordship, I agree with your lordship.
Then
They
it's the
Page-
same thing.
page
So
three-
if the appeal is allowed, then automatically
Yes.
the new seniority list will be affected.
Lordship,
So isn't it the same? I don't think it's a different matter.
lordship, that be so, lordship. Second thing,
Yes,
as
yes.
I was going through the appeal memo,
Uh-huh.
there are two documents that are not annexed in the present appeal,
Okay.
not part of, because I filed two affidavit in reply, and those two affidavit in reply is not
I can
part of
file it.
the
I'll check, my lord. It must have slipped
appeal memo.
through an oversight, maybe, but I'll file that if it is missing.
I'll check. My reply, because it will become pertinent,
Yes,
because
yes.
my learned friend has been taking your lordship to the extract of the urban development. That has been counted in my other affidavit in reply to 2, 3, and 4. And
But all those records, won't that be in the file itself?
it should be, in the rate proceeding, it was.
So,
I'm
so
just-
in the time of your argument, you can point out those files, even if it's not here.
Just pointing out, lordship, that
Yes, yes.
because of by way of the rules of the Gauhati High Court, it is the duty bound on the part of the appellant to annex all the relevant documents.
I'll do that, my lords. I'll do
Okay.
that.
That's what.
That,
Just
that
pointing out.
isn't difficult. I think you should include that in your writ appeal, all the additional affidavits that you also filed. Is it?
Yes, those were part of the writ proceedings.
An oversight on my part, my lords. I must have missed them. But I'll file them.
By way of a simple affidavit.
Okay, heard. Yes,
I'm appearing for respondent number 9.
yes.
I was allowed by this honorable court to intervene in the matter. We are the officers who are below the petitioner and the respondent number 8.
Okay, below.
In view of redesignation and remaining the writ appellant, the promotional avenues of the departmental officers have been adversely affected. Even now, after the order was passed by this honorable court, by the learned single judge, the department has issued a tentative seniority list. So the order of the learned single judge has already been given effect to by circulating the tentative seniority list. Pursuant to that, the officiating promotions have been regularized in respect of the lower officers, but in respect of the appellant and the private respondent number 8, the promotion could not be regularized because of the fact that the appellant has submitted a representation that I have filed a writ appeal and the writ appeal is pending, so our case should not be regularized. As per the standing government order, if the officiating promotions are not regularized, the promotion to the next step, next higher grade, cannot be considered. Only one promotion is allowed without regularizing the officiating promotions. Therefore, if this matter is not decided, then by
You're
the
also
end of this
affected.
year, in the month of August, some vacancy will arise. So none of them, whoever may be the senior, we are not against, nor we are not for the petitioner nor against the respondent. So far as we are concerned with our promotional avenues. And if it is keep pending in the higher level, then definitely our cases to be considered for promotion will be adversely affected. Therefore, Lordship, if Lordships are going to admit without making any observation, then my prayer is an observation may be made by this honorable court to dispose of the writ appeal expeditiously as possible.
Yes.
So as to facilitate the promotional avenues for all the employees of the department.
Maybe we can fix a date
Yes,
for
my lords.
hearing
Yes, my
instead
lords.
of in due course.
And insofar as the intervener is concerned, Your Lordship, the Honorable Single Judge has held that the intervener has got no locus standi.
Anyways, let's see. See, because the State Department also, anything to do with the court, they are scared to go ahead, isn't it?
During the pendency of the writ petition, Your Lordships, both me and the respondent number 1, we have been promoted to deputy director and to joint director also.
Okay.
So that officiating promotion has not been regularized because of the pendency of this case.
Okay, so the promotion has been taken
Yes.
place, not regularized.
Yes.
that's all.
And because of that, even the junior officers have been promoted. So it's not as if the promotion is stagnating in the department. Your Lordship.
So if it is regularized, will it be with retrospective effect or no?
No, Your Lordship.
No, it
This
cannot be.
is in the next higher post.
Okay.
In the next higher post.
The
So
officiating
right, as of now, the dispute is my entry point into the grade of ATP and the seniority thereon. But we have left the post of ATP. We are now both joint directors, 2 stages higher. So as far as I'm concerned, Your Lordship, my berth in the department, that is the issue for me. Otherwise, we have been
But
promoted.
your promotion is not affected.
No,
You are
no,
going ahead.
no. On the same
So
date.
why do you want to insist that, your birth should be?
Protected,
as per
my lord.
your,
Yes.
Initial appointment, that is her
As per
claim.
initial
Yes,
appointment,
yes.
what is
By
the
a different
benefit?
department.
What will
That
be?
concerns, Your
for
Lordship,
pension?
that concerns my entry into service in the department.
Okay, that it.
A
so
difference
it
of 6
affects-
years.
Okay.
A difference
okay.
of 6 years.
only two things, Lordship. If the claim of the appellant is succeeded in what she is claiming from 17/1/2000,
Initial
in that
appointment.
case, then it will amount to allowing her to hold the post without possessing the requisite qualification number 1.
Okay,
In
that
2004,
qualification,
both appellant and the respondent number 8, they set for the NPSC for the post of assistant town planner. The respondent number 8 passed.
No, respondent 1 passed.
Respondent number 1 passed, and the appellant failed. So, if her claim is allowed, then the conduct of NPSC will be meaningless. The existence of the service rule will also be made redundant. Because as per the rule 16 of the service rule, there are only 3 channels of entry into the service. One, that is direct recruitment through NPSC. Number 2, promotion, by promotion. And the other, which is very limited, is by absorption of deputationaries. Because one of the officers, like the present appellant, who was appointed in the PWD and posted to the Urban Development Department, and subsequently, by following due process, that officer was absorbed in the department. But so far as the present appellant is concerned, she is yet to be absorbed in the department.
But he says that I've been there all along.
Yes.
But his praise that I've been there all along. So let's see.
The
Let's see.
department was very kind enough
Yes.
to accommodate her. Otherwise,
not only
initial
that-
appointment is by the PWD.
So let this matter be heard thoroughly.
Yes.
Okay.
General report
There are points.
in the PWD, leave was availed from the PWD department. Now, after the designation on the 20th September 2006, she is claiming that no, my initial appointment was
Way back.
wrong.
When she first joined, isn't it? Yes.
Why for
Got
the
your
last
point.
6 years there was no such complaint? If it is wrong. Therefore, redesignation is treated as a weapon to squeeze into the department and
All these-
obstruct the promotional avenues.
All these
of the
arguments, my lords, by a person who has been held
so
up, no
let
locus
there be a
standi.
proper argument on that. Okay. I don't think it can be disposed of at this admission hearing.
Those submissions, my lord, should come from my real friend, respondent number 1.
Lordship,
Not from a person who has no locus
I'm ready
standi.
to make the submission. I'm ready to make
So,
the,
so,
but because
so,
of the
yes, so
anxiety
since
shown
we
by
feel
the
that he has a
lawsuit-
point to appeal against the judgment and order of the single this thing, we will admit the appeal and then we'll hear the matter.
the only objection will be
Yes,
there should be
yes.
no stay order at this stage.
Okay. He's not pressing on that, so let's leave that aside. Okay. Heard Mr. A.
Izimomi, my lord.
Izimomi, learned counsel for the appellant, along with Mr. C.T. Zamir, senior counsel for respondent number 9, and Mr. Apok Pongender, learned counsel for respondent number 1. Having heard the submissions made by the learned counsels, the court we find it fit to admit the appeal. List this matter for hearing on. When do you want it? On during the month of May?
17th May, my lord.
On 17th May 2023, since the counsels for the parties have expressed that there is urgency in this matter. Yes. Accordingly, yes.
Lordship, I forgot to mention, due to some clerical mistakes, I have filed a review petition also, which is pending because the bench has not been constituted at Kohima.
Okay, review petition before the.
The review petition has been filed here, and the same bench has not been constituted ever since.
Okay.
Just
So what to do? Okay, this is just for our knowledge, isn't it? Review petition when it comes up. Review petition,
to make some correction on it.
correction of what?
Paragraph 20 of the judgment.
Yes.
Instead of petitioner, it was shown as respondent number 8.
Okay, so maybe we list the review petition along with this matter? So hearing of the, no, I don't think so.
Whether that will be possible, that is the question. because the review has to go to the same court.
So you have filed a review petition in the division bench?
No.
Single? Then that,
Yeah. Just
okay.
making
Yes,
information.
this is for our information, Yes.
Much obliged.
For orders, item number 20.
Yes. Matter is called out. None appeared for the parties. List this matter after 2 weeks.
For orders, item number 21.
Yes, item number 21.
Your
This
Worship,
is an IA. IA is for what?
Your Worship, I is
Condemnation
for
of delay?
condemnation of delay.
Of
Going for
26 days.
26 days. Worship, however, the state council is not here.
Someone should be there, government advocate. And this is sentences for how many years?
20 years, Worship.
15.
Not
Okay.
20.
20? Then can be taken up. Where are all the government, councils, call someone. Otherwise, we'll issue notice fixed.
Worship, notice has been issued on last occasion.
This is an IA, isn't it?
Worship, I.
Along with the IA, where's the case? Yes. But here also I've noticed this condonation of delay is a different matter. But in the main,
In the main appeal, Worship,
okay, we have not, you have included the informant?
the victim, Worship, sumo to case.
Okay. Notice is yet to be issued. Have you made the,
Victim as a party, Worship. Parties are respondent number 2.
okay. Yes, respondent number 2 is
Yes,
there.
Worship.
No?
Yes,
Yes,
Worship.
that's
Yes.
what I'm just wanting to know.
Worship,
The
since
victim has been represented.
Worship,
Yes.
the notice was issued in the IE on last occasion.
So we'll dispose of, this is a, but notice is issued to the state, isn't
State-
it? So state you could have just given it to them also. This is a condemnation of delay of 26 days.
26 days only,
Just
Worship.
we allowed it. None have appeared. I mean, I don't think we have to adjourn the matter for just 20 days, 26 days. And this is an appeal against conviction, isn't it? What is the reason for the delay? What is the reason for the delay?
Worship, the reason for delay was, Worship, this appeal has been filed under the initiative of the High Court Legal Services Authority.
Yes.
And Worship, the file was endorsed to the council on 15/12/2022. That means last year, December. But Lordship, since the winter vacation of this bench started from 18 December till 17 January, the engaged council was out of station. So only after reopening of this court, the present appeal was filed. So in the meantime, a delay of 26 days is happening.
Heard, Mr.
Lima Wapang, Lordship.
Ima Wapang, is it? Right, Mr. Lima Wapang, learned counsel for the applicant slash appellant, who has filed this application for condonation of delay of 26 days in filing the criminal appeal against the judgment and order dated 22/11/2022 and against the sentence order dated 23/11/2022 passed by the special judge POCSO, Twensang, Nagaland, NGR number 37/2019.
2017, Lordship.
Yes,
No, 19, Lordship.
it's 19.
Yes, Lordship.
Find out which was correct.
It's a typing mistake, Lordship. Yes.
It has to be 17.
It is 19, Lordship. It has to be.
19. So 19 is correct, isn't
Correct,
it? Not 17.
In my cost table, it's given 17. Lordship.
Okay. So please make that correct. 2019. It is seen that notice was issued and Mr. V. Zimo Momi, learned PP, had accepted notice. Okay, you're present. Okay.
Lordship.
Okay, Mr. V. Zinomoti, learned PP, on behalf of the state respondents is present. Okay. Any objection?
No.
Is present and has not raised any objection to the condonation of delay of 26 days in filing the connected appeal. The learned counsel for the applicant/appellant has explained that the delay of 26 days in filing the appeal is due to the fact that the appeal was taken up by the district or
No,
state,
Lordship. High Court Legal Services Authority.
was taken up by the High Court Legal Services Authority. And time was taken for appointment of the counsel. Is it counsel for the appellant? We find that there's merit in the reasons given for the delay of 26 days in filing the criminal appeal against the judgment and order dated 22/11/2022. In view of the above, IA within brackets criminal -1 2023 stands allowed and disposed.
Lordship, in the main appeal, we have taken several grounds, but one of the main grounds is that in the prison case, the victim is a child, is a girl. As per the POCSO Act, when the victim is a child girl, it has to be examined by a lady doctor.
Okay.
However, in the prison case, she has been examined by a male doctor. And the findings of the trial court is based on the report submitted by the medical officer. So, Lordship, the appeal may be admitted in the LCR may be called.
Yes, on the disposal of the IA within brackets criminal 1 of 2023, heard the learned counsel for the appellant who submits that the appeal against the judgment and order dated 22/11/2022 passed by the Special Judge POCSO, Twengsang in GR number 37/2019. And convicting the appellant/accused under Section 5 POCSO Act, punishable under Section 6 of the POCSO Act. Your
Yes, Lordship.
synopsis is
Punishable under
there.
6.
Yes, wherein the appellant was sentenced to undergo,
20 years.
where is the sentence portion? Let me find. Page what? You've simply mentioned, in your appeal petition, have you mentioned the term of sentence?
Yes, Lordship.
Where? It's not there in the, straight away in this also. Synopsis also you have not mentioned.
Your Lordship may come to page number 49 in the judgment.
It should be there straight away, enough for us to see, not
Lordship,
in
here,
the end.
yes, convicted under Section 6 in punishable
You are
under
reading
Section-
the sentence order, okay? But in your appeal petition, nothing has been mentioned. You see, you should also mention for how long he has been sentenced, the term of sentence anyways. He has been sentenced to undergo
20 years, page 49.
RIF of 20 years and pay a fine of 10,000. ID in default, a further sentence of 6 months within brackets SI. The learned counsel submits that the above judgment and order is liable to be set aside since the learned trial court had relied mainly on the medical report wherein the doctor who examined the victim girl was a male
male.
doctor, which is not in consonance with the POCSO Act. Appeal is submitted. Mr. So-and-so, learned PP accepts notice on behalf of the state respondents. Requisite copies of the appeal to be furnished to the government. Learned PP issue notice to respondent number 2 through registered post with AD within 3 days.
3 days, Worship.
Returnable by 3 weeks. List this matter after 3 weeks.
Worship, the ELCR may be called for. I need an early hearing. ELCR.
Meanwhile, LCR is to be called for. Yes.
This week, 3 बजे
Item number 1.
कल हमारा notes कहाँ 10 तक रखा हमें वो notes बनाए थे
Your notes.
My notes. Yes. So we are going to continue from your citations. Is
Yes,
it?
Your Lordship.
You have them ready?
But before that, yesterday, as I was hurriedly attempting to finish my submissions, I may have missed out a point or two, if I may be allowed to make those submissions
Regarding
quickly.
what?
Yes,
Which
one.
one?
Instead of making submissions, I would just like to read out from my affidavit in reply. One affidavit
Okay.
in reply to the affidavit in opposition of respondent number 1 and 2, the state respondents. Affidavit in reply to the affidavit in opposition of respondent 1 and 2.
This is dated 20th June 2022, is it?
Yes, 20 June.
Yes.
2022. At paragraph 7.
Hmm.
I will just read out the elements. That the deponent denies the statement made in paragraph 3.6 and reiterates that there is nowhere in the Act or the regulation that bans the distribution, sale, or import of dogs and dog meat for human consumption. The construction placed by the state does not advance the intent of either the Act or the 2011 regulations. However, even assuming but not admitting that the argument of the state is to be applied in respect of the definition of animals contained in Regulation 2.5.1a of the 2011 regulations, then the other species of edible animals not found mentioned in the said regulation, such as bees, bee larvae, frogs, eels, woodworm, snail, white mice, etc., which are readily found openly sold in the local and indigenous markets at TKL Market BOC Kohima Town and Supermarket Kohima Town, ought to have necessarily faced the same fate. But they have not. As a corollary, therefore, discrimination is writ large on the petitioners who trade in the import and sale of dogs and dog meat vis-a-vis the other traders who deal in the trade of sale of the above stated species of animals, despite being not mentioned anywhere in the definition of animals under Regulation 2.5.1a. So these are some of the animals, species of animals, which are not found. As your Lordship has seen yesterday, that in the definition of animal, these species are not found. Neither in the regulation, as I had taken your Lordship yesterday, none of these species are found. And my submission is that these species should also have faced the same fate as that of dog, but they have not. Therefore, my submission is that the circular as well as the impute notification, based on that interpretation, is flawed. And is not found anywhere. Such an interpretation cannot have any basis from the Food Safety Act or the regulations of 2011.
Yes.
And finally, the Act, the Food Safety Act, it is a central act. Now, it has a pan-India effect, and it affects the entire citizens of India. So, the Act had repealed under the second schedule, as I had shown yesterday, those 8 enactments. And when those 8 enactments were in existence prior to the coming of this Act in 2006, no such notification or the impugned circular that is in existence now was issued prior thereto. No such notifications or circulars were issued banning the consumption of any specific animal. But and the intention of the Act, which can be read from the preamble as well as the other provisions of the Act, nowhere suggests that this Act was intended to control the dietary habits of the citizens of India, which includes the petitioners as well. It was not meant for controlling, but for regulating and monitoring, so that the citizens get safe and wholesome food. That being the intent. The Food Authority, by its impugned circular, as well as the state by the impugned notification, is indirectly trying to control the dietary habits of the petitioners, and if I may say so, the entire public or the citizens as well of India, the public of Nagaland.
Okay, yes.
And therefore, as your Lordship is well aware that the duty of the court is to interpret the law, that interpretation has to be something that has to subserve the purpose of the Act. And the Act, in my humble submission, the intention is not to control the dietary habits.
Okay.
And this submission will be interlinked with the right to privacy under Article 21. And I would like to now refer to some of the citations which I have prepared. I may be allowed to
Yes.
give one list where I have mentioned the propositions as well as along with the propositions, the authorities which I'm relying upon for your lordship's
Okay.
assistance.
Yes,
I've already
okay.
supplied the book list, but this is for your lordship's
Oh.
assistance.
Yes.
So the impugned circular dated 6/8/2014 and the impugned notification dated 4/7/2020, read with Agenda 8 of the Cabinet Memo dated 4/7/2020 are ultra vires the Food Safety Act for the following propositions of law. And the first proposition is if interpretation of food authority and state is accepted, it would amount to delegated legislation, that is the Food Product Standard Regulation 2011, narrowing the scope of the parent act, that is the Food Safety Act, thereby limiting the operation of the definition of food under Section 3J of the Act. For this proposition, I'm firstly relying on one Supreme Court's decision reported in 2015 9 SCC 209. 2015 9 SCC. Page 209.
Yes.
Only the principles of law.
Yes,
Where in this
paragraph-
decision,
Oh.
paragraph starts from paragraph 45 to 43. I'm relying on those paragraphs, where the Supreme Court has in a way compiled all the principles of law insofar as it pertains to delegated legislation.
Yes, paragraph 45.
Paragraph 45.
Yeah.
If I may read out.
Yes.
In Saint so-and-so, it has been observed that a regulation is a rule or order prescribed by superior for the management of some business and implies a rule for general course of action. Rules and regulations are all comprised in delegated legislations. The power to make subordinate legislation is derived from the Enabling Act, and it is fundamental that the delegate on whom such a power is conferred has to act within the limits of authority conferred by the Act. Rules cannot be made to supplant the provisions of the Enabling Act, but to supplement it. What is permitted is the delegation of ancillary or subordinate legislative functions, or what is fictionally called a power to fill up details. 46. In so-and-so, it has been ruled that it is very important for the legislature to provide for a general rule-making power to carry out the purpose of the Act. When such a power is given, it may be permissible to find out the object of the enactment and then see if the rules framed satisfy the test of having been so framed as to fall within the scope of general power confirmed. If rule-making power is not expressed in such a usual general form, then it shall have to be seen if the rules made are protected by the limits prescribed by the parent act. 47. In so-and-so, it has been stated that it is a well-settled principle of interpretation of statutes that the conferment of
Your Honor?
rule-making power by...
Sorry to interrupt. I just wanted to ask, I mean, we haven't gotten a copy, but the authorities relying on seem to be in relation to whether delegated legislation, whether those regulations are appropriate or not. But for the purposes of this present writ, the petitioner has not challenged the regulations. So
I think
My
it
learned
is
friend
not
can make necessary
challenging the
submissions.
regulations, but it is the interpretation of the regulation.
That is
While
one.
passing the
Yes, Your
notification.
Lordship.
I
That
don't
is one
think can make
contention, Your
necessary
Lordship.
submissions in
It is not an interpretation. It is a regulation verbatim. And so when
you'll
the,
make a submission.
Yes,
His point is.
if I
yes,
may get a copy as well, please.
Yes, give a copy.
I don't have an extra copy right now, but I can supply.
Later. So I don't think your submission, which you had made, is with regards to the regulation, but I think it is in the interpretation of the
Yes, in the
regulation.
interpretation only.
Oh.
I'm saying that the
So
regulation
I-
is intra-vires. It's intra-vires,
Oh,
but the interpretation makes the
So,
impugned circular.
yes, so as pointed out, I don't think we have to go into the legality of the
No, I'm
regulation.
I'm not going into, I have not gone into the legality,
Oh.
but just to highlight before this court the principle on delegated legislation and how a delegatee should act. If we are to accept the impugned circular and the impugned notification as being correct, then this, I'm saying that my submission is that these principles will be violated.
Okay, so
If-
you're saying that the notification,
Yes.
okay, is in violation of the principle of the Act.
Yes, if
Okay.
accepted to be as true.
Yes, okay, fine.
So these are the,
So,
to cut it short, I can come down to
just cut
53.
your arguments a little bit short.
Yeah,
Just
53
because we have
last.
got your point.
But I'll be relying on 45 to 53. I've already noted that down in the
Yes,
in the
yes, yes.
document provided.
So
In the-
gist is that it cannot go beyond the Act.
Yes,
Isn't
yes,
it? Yes.
yes.
Okay.
And
Then,
so basically that's the principle. And for that purpose also I have relied on the other two decisions, 2004 8 SCC 747 paragraph 13. And the other one is 1974 1 SCC 167 paragraph 14.
yes, yes. So your point is that this regulation is only to supplement the Act,
Yes, and this regulation,
not beyond the Act.
yes, it is
No.
intra-virus. I'm not
Yes.
saying that it is ultra-virus,
Yes,
but I'm
yes.
saying
So
that
it's intra-virus the
yes,
Act.
I'm saying that the impugned circular and the notification, they are ultra-virus the Act
Okay.
because of the interpretation.
Yes,
adopted.
yes, yes. Okay.
Yes, all right. The next proposition is, if interpretation of food authority and state is accepted, the definition of animal under regulation 2.so would be contravening the definition of animal under section 2A of the Prevention of Cruelty to Animals Act. It is settled law that delegated cannot contravene neither the Parent Act nor other parliamentary acts. In this regard, I have placed 3 citations, but to save time, I'll just read out maybe 2, 1. One is
So this food authority and state, okay.
Yes.
The food authority had also passed that
Yes,
order.
the impugned
So
circular.
all the states, yes,
Yes,
okay,
yes, that
okay.
direction was
Yes,
given.
yes.
Yes. 2006 4 SCC.
Hmm.
2006 4 SCC. Two 2006 4 SCC, paragraph 17. Only one paragraph. Paragraph
Yes.
17.
Yes.
A rule is not only required to be made in conformity with the provisions of the Act, whereunder it is made, but the same must be in conformity with the provisions of any other Act, as a subordinate legislation cannot be violative of any plenary legislation made by Parliament or the state legislature. Therefore, the impugned circular contradicts the definition of animal under the Prevention of Cruelty Act.
Okay, fine.
Now, as I was submitted yesterday, under
Yes.
Prevention of Cruelty, there's no prohibition to kill dogs.
So point number 1, your citations in 1 and 2 are more or less similar,
Yes.
isn't it?
So even the other, may I be allowed to place one more citation?
one
in this?
more, huh?
Yeah. 1989 4 SCC. 1989 4 SCC. On the same principle, but the phraseology being different, I would just...
98.
Yeah. 98, yes.
Yes.
Your Lordship may come down to while ordinances.
Yes.
Yes. While ordinances cannot perhaps be questioned on any ground which is not relevant to the validity of legislation, it is not so in the case of rules made by virtue of power granted under the Constitution, which are, as stated above, liable to be declared void for any of the reasons for which instruments made by virtue of delegations by acts of Parliament can be declared void. Rules, whether made under the Constitution or a statute, must be intra vires the parent law, under which power has been delegated. They must also be in harmony with the provisions of the Constitution and other laws.
But I don't think there's any rule that
Yes.
has been made.
My
This is just an
submission is
order.
in this regard
Yes.
is that the impugned circular and the impugned notification violates the definition of animal under the
Yes.
Prevention of Cruelty to Animals Act.
But I don't think there's a rule that has been made, isn't it? No rule. That's
In
just
this
a
regard,
circular.
rule means the regulation. Rule, regulation, they are used interchangeably.
But you are not against the regulation, you are against the circular made by the
circulated.
Food Authority,
Yes,
which
yes.
is actually not a rule, I think.
Uh,
Anyways. So that's a circular.
Yes,
not
it's a
rule.
circular.
Yes.
And then the
Anyways.
next one is proposition. The definition of animal under Regulation 2.5.1a cannot be read into the definition of food under Section 3J of the Food Safety Act, as there is no deeming provision.
Okay.
Here,
Let's see this.
1993 Supply 4 SEC.
Para 31.
Para 31, your lordship makes straight away come down to between placitum E and F, the necessity. Between placitum E and F, the necessity and significance. The necessity
Yes,
The
yes, go
necessity
ahead.
and significance of the delegated legislation is well accepted and needs no elaboration at hence. Even so, it is well to remind ourselves that rules represent subordinate legislation. They cannot travel beyond the purview of the Act, where the Act says that rules on being made shall be deemed as if enacted in this Act. The position may be different. It is not necessary to express any definite opinion on this aspect for the purpose of this case, but where the Act does not say so, the rules do not become part of the Act. So the regulation in the Act, there is no deeming provision where it says that the regulation will form part of the Act. And under Section 3J of the Act, the definition of food, your lordship had seen that yesterday, reference have been made to animals. The word animal is used in the definition food.
Okay,
Yeah,
yes.
live animals or animal feed. That animal cannot mean to the definition of animals under Regulation 2011. My submission is that because there's no deeming provision making that animal part of the definition of food under,
The regulation.
yes, under the Act. Therefore, since there is no deeming provision, the word animal has to be understood in the common sense, or at best as to what is mentioned, as to what is defined under the Prevention of Cruelty to Animals Act. Because the
Okay,
definition,
so you're saying that the definition of animal under the regulation should not be read as food under the Act.
yes,
Isn't it?
because the
Yes.
food itself it has a very wide import.
Mm-hmm.
And the next, this is power of the Food Authority to regulate under Section 16 of the Act does not include the power to prohibit, except according to the procedure laid down in the Act. Even otherwise, the Act, read as a whole, is not intended to control the dietary habits of the citizens of India. And for this, I'll be skipping this, but the AIR's 1967
Okay,
paragraph.
okay. Oh.
Again, your lordship had seen that the chief secretary has no authority to issue any prohibition orders under the Act, for which proposition, just one, 1989 3 SCC. Para 20.
Yes.
Para 20. Counsel for the appellant argued that the express power of the Vice Chancellor to regulate the work and conduct of the officers of the university implies as well the power to take disciplinary action against officers. We are unable to agree with this contention. Firstly, the power to regulate the work and conduct of officers cannot include the power to take disciplinary action for their removal. Secondly, the Act confers power to appoint officers on the Executive Council, and it generally includes the power to remove. This power is located under Section 24(1)(29) of the Act. It is therefore futile to contend that the Vice Chancellor can exercise that power which is conferred on the Executive Council. It is a settled principle that when the Act prescribes a particular body to exercise a power, it must be exercised only by that body. It cannot be exercised by others unless it is delegated. The law must also provide for such delegation. Again, and after that, Halsbury's law quoted. So, in a similar manner, 1994 5 SCC also reiterates the principle that it has to be the authority which have been delegated which can issue the necessary orders. Chief Secretary in the Food Safety Act has no authority, no delegation has been made to the Chief Secretary to issue such impute notification. Again, for the proposition that the procedure established by the Act in issuing the prohibition orders must be followed before the petitioners can be deprived of their rights. Now, no procedure has been followed under the Act, and for that I have relied on. Maybe I'll skip that. And for the proposition that there can be no violation of Article 19 and 29 by an executive fate, if that is on the presumption or assumption that if the Act is not applicable in the instant case, and supposing the notification is to stand by itself, then even in that manner also the executive cannot, by its executive power, deprive the petitioners of the fundamental right under Article 19 and 21. For that, I have relied on these three propositions of three citation authorities. And the violation of natural justice, no opportunity was given for us to do anything.
Okay, not heard.
And yes, finally, the last authority is the impugned circular and notification are violative of the right to eat dog meat, as well as the belief on the benefits that the dog meat provides, which are facets of the right to privacy. For this, I may just be allowed to read two paragraphs from 2007-10 SCC. Putuswamis, 2007-10 SCC.
2017.
Then 2017-10 SCC. Yesterday, Your Lordship had seen that the custom is firmly established that there is a belief that dogs' meat or its soup provide medicinal benefits. Scientifically, it may or may not be true, but this belief, my submission is that it is a facet of the right to privacy and it cannot be violated in the manner in which the circular as well as the pre-notification has been issued. And for this proposition,
Okay, what type of medicinal value does it have?
maybe the benefits that
Benefits?
yeah, benefit. Maybe it has benefits. It
Okay,
provides
what?
benefits.
Content of protein is high or what?
That I'm
Meat,
not aware, but
chicken, what?
even
Oh, okay.
in the books that I've cited yesterday,
Oh.
there's references that it has medicinal benefits. Paragraph 297.
297.
Here, the Supreme Court has discussed the essential nature of privacy, and I'd just like to read out two paragraphs. If your Lordship may kindly bear with me. 297 and 298. 297. What then does privacy postulate? Privacy postulates that the reservation of a private space for the individual, described as the right to be let alone. The concept is founded on the autonomy of the individual. The ability of an individual to make choices lies at the core of the human personality. The notion of privacy enables the individual to assert and control the human element, which is inseparable from the personality of the individual. The inviolable nature of the human personality is manifested in the ability to make decisions on matters intimate to human life. The autonomy of the individual is associated over matters which can be kept private. These are concerns over which there is a legitimate expectation of privacy. The body and mind are inseparable elements of the human personality. The integrity of the body and the sanctity of the mind can exist on the foundation that each individual possesses an inalienable ability and right to preserve a private space in which the human personality can develop. Without the ability to make choices, the inviolability of the personality would be in doubt. Recognizing a zone of privacy is but an acknowledgement that each individual must be entitled to chart and pursue the course of development personality. Hence, privacy is the postulate of human dignity itself. Thoughts and behavioral patterns which are intimate to an individual are entitled to a zone of privacy where one is free of social expectations. In that zone of privacy, an individual is not judged by others. Privacy enables each individual to take crucial decisions which find expression in the human personality. It enables individuals to preserve their beliefs, in this regard, beliefs, thoughts, expressions, ideas, ideologies, preferences, and choices, which against societal demands of homogeneity. Privacy is an intrinsic recognition of heterogeneity, of the right of the individual to be different and to stand against the tide of conformity in creating a zone of solitude. Privacy protects the individual from the searching glare of publicity in matters which are personal to his or her life. I'll skip down
Okay,
to
yes,
him.
come to the relevant part.
298.
Huh?
Privacy,
298.
298. Privacy of the individual is an essential aspect of dignity. Dignity has both an intrinsic and instrumental value. I'll skip down and then
Yes, yes. Where's
here
the health part?
the reference
Brief.
is made at read in conjunction with Article 2.1. Read in conjunction with Article 21.
Okay, where's that?
I
In the end of the
just-
para?
Yes, almost at the end.
Okay.
Read in conjunction with Article 21.
Yes, okay.
Yes. Liberty enables the individual to have a choice of preferences on various facets of life, including what and how one will eat. And therefore, the impugned circular.
So you're saying that they believe it has medicinal value.
Yes. So
And
that
this
belief
can be covered under
yes,
right
it
to
has
privacy.
to be covered under the facets of
Okay.
the right to privacy, which has been declared a fundamental right by this judgment. And in the how to eat, what to eat, the Act does not provide any mechanism on how to control the dietary habits. It is mainly to subserve the purpose of making available safe and wholesome food, not for controlling the dietary habits.
Okay.
And therefore, the impugned notification and the circular, as well as the cabinet memorandum, it has to be declared as ultra vires the Food Safety Act. That is
Okay.
my humble submission.
But this circular made by this food safety, whatever,
Yes.
it's a circular which has been made by the central.
Yes.
Okay, the concerned, huh?
Yes. The
Okay.
food safety is an autonomous body under the Ministry of Health.
Ministry of
Yes,
Health.
under Ministry of Health.
Okay. Hmm.
They've been made parties. They've also filed their affidavits. Yes.
Oh, they have been
Yes,
made
they
a
are also
party?
represented.
Who's appearing for the central? Okay, fine. Okay.
I conclude my
Yes,
submissions. I'm
yes,
obliged.
yes. Yes. You are representing?
I'm representing respondents number 6 and 7, Your Lordship.
Okay, yes.
They are organizations, non-government organizations, working across the country to protect the interests of animals. Their activities include, among others, policy development for the welfare of animals, reform, capacity building of law enforcement agencies, and direct care, including animal birth control programs, sheltering, etc.
Okay. 6 and 7. Where is the affidavit?
Your Lordship, it's
Have you filed the affidavit?
we've filed the affidavit, Your Lordship.
Pardon?
We've filed the IA. We requested for the IA to be treated as the counter, Your Lordship.
Okay.
IA
So in the
27.
IA,
IA 27, Your
okay,
Lordship.
because I don't see your affidavit here
Sorry, I made the submission last week.
previously, yeah? Okay. So your IA is to be treated as your affidavit in opposition.
Yes,
Fine.
via order dated 23/2023, Your Lordship.
Okay, fine.
Your Lordship, I'll just provide an overview of the submissions that I would like to make.
Okay.
The main contentions of the petitioners have been that there are no provisions, express provisions in law to make this restriction as the interpretation, as the petitioner calls it. But there is a specific regulation in law. It has been repeatedly mentioned in the petition as well as the amended petition. It's regulation 2.5.1a of the food product standards and food additives regulations of 2011. I will also refer to the basis on which these regulations were made. The second contention was that the chief secretary is not empowered to issue such a notification. I will elaborate on how only is it not the chief secretary's responsibility as the head, the administrative head of the state, but also his constitutional duty to ensure there is enforcement of law. There is a contention that there is no scientific data on the basis of which such a prohibition was created, and reference is made to certain sections of the Food Safety and Standards Act, sections 34, 36, 38, and so on. And I believe my learned counsel colleague also made references to some sections which I did not find in the petition, but I would like to respond to all of those as well. Another contention similar to the second contention is that the executive is not authorized to make such a prohibition. The next contention is with regard to customs. I would like to elaborate on how there are no basis to the citations made and that they are dated, and there are certain criteria to determine what practices and usages can be considered customs. There is a contention, there is a challenge in the amended writ to the order dated 6/8/2014, the circular of the Food Safety, the Directorate of Enforcement, Food Safety and Standards Authority of India, which has repeatedly been called an interpretation. But I would like to take Your Honor through the circular itself to point out that it is a verbatim replication of the regulation as it stands, and it is not an interpretation. But the primary submission at the onset that I want to make, Your Honor, and to borrow my learned colleague's words, what is writ large in the submissions made by the petitioner, whether in writing or otherwise, it seems that the petitioner is attempting to set aside or not be included or not be governed by the regulation, but has not challenged the regulation. They have only challenged the circular as well as a notification of the state government, both of which are a verbatim replication of the law as it stands. neither is an interpretation. There is nothing barring a government, whether state or the center, in issuing directives at any given point when it deems fit, if they find that there is violation at the time of reporting. There are various factors and instances which can motivate the government, the executive, to issue orders to reiterate the enforcement of an existing law.
Okay. So you're saying that this is just an enforcement of the regulation?
It is an enforcement of the regulation. It is not an interpretation. I will elaborate on that, Your Lordship, one by one on all of these arguments. But I want to request that it be considered that this submission is recorded, that the challenge is not to the regulation, yet by getting a ban, getting a stay on the ban, they have effectively put a stop to the enforcement of the regulation itself without even challenging the regulation. And this is a very backhanded method and very unfortunate that the law, the central legislation, is being prevented from being enforced without even being challenged on merits.
Yes.
The first, to elaborate on the first contention, that there is no express provision in law, I beg to draw your ladyship's attention to the food safety and standards rules. I will not read most, I will only read the relevant portions, but I must take your ladyship through the statement of objects and reasons of the food safety and standards law, and not just the purpose. This law came about because there was a multiplicity of food laws. The standard setting and enforcement agencies pervades different sectors of food, which creates confusion in the minds of consumers, traders, manufacturers, and investors. Detailed provisions under various laws regarding admissibility of levels of food, additives, contaminants, colors, preservative, etc., and other related requirements have varied standards under the law. The standards are often rigid and non-responsive to scientific advancement and modernization. In view of the multiplicity of law, their enforcement and standard setting, as well as various implementing agencies, are detrimental to the growth of the food industry and is not conducive to the effective fixation of food standards and their enforcement. The very objective of amalgamating various laws was to ensure that the enforcement was effective, because there was no uniformity. The intention of this legislation, the intention of the the intention of the lawmaker is to ensure that wholesome and safe food is available, only food which is safe for human consumption, and standards are accordingly set.
Okay.
Now, while the definition of food is provided at 3J and 2K, and I won't, for the sake of brevity, read them again. But what I do want to point out is that the regulations themselves don't narrow the definition of food. The regulations are specific. It has been repeatedly stated that this is a technical legislation. I would like to supplement the term technical for the word special. Special legislations are created for specific subjects because there is a specific requirement for understanding the technicalities of it, but it is a special legislation. Just like the Prevention of Cruelty to Animals Act and the Wildlife Protection Act, each of these laws have a specific purpose. While there may be stray provisions of law in different legislations, these laws are made with specific purposes. The Prevention of Cruelty to Animals Act is made with the purpose to prevent the infliction of unnecessary pain and suffering on animals. The Wildlife Protection Act is made with the purpose of protecting and preserving wildlife and natural habitats. And so it is not narrowing the scope of the definitions, but it is in fact making specific regulations for different subject matters within the special legislation to which these regulations will be applicable. For instance, in the Prevention of Cruelty to Animals Act, there are transport of animal rules. There are rules for draught and pack animals, animals that are specifically used for the purpose of carrying weight.
Yes.
So it does not mean that
enactments.
it's a special enactment. It is
Specific purposes.
for specific purposes. So it does not mean that the rules or the regulations under that special enactment are narrowing the scope. They are there to carry forward the purpose of that legislation and to make sure that the regulations are specific to those instances. There are rules that govern rotten pack animals, rules that provide standards for how animals are to be transported, rules for dog breeding industry, rules for pet trade, so on and so forth. Similarly, in the Food Safety and Standards Act, these specifications are made under the law. I will take your ladyship draw your attention to section 92. Section 16 and 92 have already been read out to you. There is power of the Food Authority to make regulations under this act. And yes, it is delegated legislation to ensure to the central government to ensure that the purpose of the act is carried forward. What is also essential, and I'll read 92(1)(2)(e) for that purpose. In particular, and without prejudice to the generality of the foregoing power, such regulations may provide for all or any of the following matters, including notifying standards and guidelines in relation to articles of food meant for human consumption under subsection 2 of section 16. So to define what are the articles that are meant and fit for human consumption may also be covered in these regulations or guidelines as the authorized agency deems fit. I want to draw your attention also to section 93, your ladyship. Laying of rules and regulations before the parliament. Every rule and every regulation made under this act shall be laid as soon as may be after it is made before each house of the parliament while it is in session for a total period of 30 days, which may be comprised in one session or in 2 or more successive sessions, and if before the expiry of the session, immediately following the session or the successive sessions aforesaid, so on and so forth. The purpose of this section, your lordship, is to make sure that the rules are laid before the parliament and they have the full consent of the Parliament of India before they come into enforcement. It is a stopgap. There is a period of 30 days as well. The regulations made under the Food Safety and Standards Act are procedurally, statutorily required to be placed before the House of Parliament. Before this step, your lordship, the draft regulations are always published for public comments. Public comments are invited, considered by the body, which is then finalized and laid before the parliament. So I take vehement opposition to the fact that no considerations have been made or stakeholders have not been consulted. There was enough and more time. These regulations came in 2011, 5 years after the Food Safety and Standards Act itself. So
Okay, yes. So the public means the instant petitioners, we're also aware, is it?
Yes, your lordship. Ignorance of law cannot be an excuse, your lordship, and that is also something that is claimed prior to the amendment of the writ, that the petitioners were not aware that a circular of the Food Safety and Standards Authority of India existed. But again, I will reiterate that that circular is a verbatim reproduction of the law with just a direction to enforce the law as it stands. Your lordship, the definition, again, it was claimed that the definition is narrowed in the 2.5.1. I reiterate that it is not narrowed. These regulations, particularly this chapter in the Food Product Standards and Food Additives Regulations 2011, are specific to what these standards apply for what is meant for human consumption, that is provided for in the definition of animal. The definition of animal in the Prevention of Cruelty to Animals Act and the definition of animal in food safety, I don't believe that there is a correlation, because again, these are two specific legislations and they have two separate purposes. In a while, I will also take your ladyship through the PCA Act and the section 11.1, section 11.3, where the exemption is provided and what that entails. The one portion of the Food Safety and Standards law that has not been brought to your ladyship's attention, which I beg your ladyship's leave to do so, is the Food Safety and Standards Licensing and Registration of Food Businesses Regulations 2011. These regulations are provided to ensure that certain standards are followed in the preparation of food, in the processing of food, and in the sale of food. Chapter 4 of these regulations particularly deal with slaughter and transport of animals for slaughter. I'm not sure I have the same copy as your ladyship. So I'm at page 139 in my Bear Act. I'm reading out chapter 4, your ladyship.
Chapter 4.
Chapter
specific
4.
hygiene.
Specific hygiene.
Yes.
Specific hygiene and
Yes.
sanitary practices to be followed by food business operators engaged in manufacture, processing, storing, and selling of meat and meat products. There are specific standards of how all of these practices are to be carried out, and there are 3 distinct licenses that are provided, your ladyship. A license for slaughterhouses where animals are to be slaughtered, a license for meat shops where animals may be sold, and a license for meat processing units where slaughtered meat is processed. These standards are specifically there to ensure safe food. And these are 3 distinct licenses, your ladyship. There is no provision in law where one license can be used for another. A meat shop can't slaughter animals. They can only sell meat. A slaughterhouse can't slaughter and sell animals. They're only to slaughter animals. And all of this is essential because the structure of each of these units is also provided for in the standards. The infrastructure that is essential for a slaughterhouse to ensure that the animals are separate, that the offal generated is separate, that waste treatment is required, because slaughterhouses are a red category industry under the environment regulation. They can wreak a lot of havoc in the environment. And so these standards, the infrastructure is very essential to ensure sanitation, public health, and food safety.
Yes.
Now if I may draw your ladyship's attention to the second contention, that the chief secretary is not authorized. I'm reading out, your ladyship, Article 256 of the Constitution. The obligation of states and the union. The executive power of every state shall be so exercised as to ensure compliance with the laws made by the parliament and any existing laws which apply in that state, and the executive power of the union shall extend to the giving of such directions to a state as may appear to the government of India to be necessary for that purpose. The circular is made because the union deemed it fit. That direction is given for enforcement of an existing law in 2014. The state government deemed it fit to issue direction via a notification seeking the enforcement of the same law for whatever reason it deemed fit. Whether it was because it came to the state's attention that the law was being violated, the memo, the cabinet memo should provide the reasons. But it is not just the power of the chief secretary, who's the administrative head of the state, who has in his authority to ensure law enforcement, but it is his constitutional duty to do so. Your Lordship, there is provisions of the constitutions that were also referred to, that is Article 19(1)(g) and Article 304. Now, the relation to Article 19(1)(g), Your Lordship, it goes without saying that no freedom is absolute. There are reasonable restrictions. And the constitutional right of free trade also is not absolute.
That it comes within the reasonable restrictions.
It comes within the reasonable restrictions, Your Lordship. Trade is the buying and selling of goods for profit. It is not appropriate to read Article 304 in silos. Article 301 to 307, the concept of which is derived from an Australian constitution, is to ensure that trade occurs efficiently, fairly, but within reason. The term free here does not mean that there is freedom from flouting existing law or freedom from governing rules and regulations that are developed by the country. There is a very significant distinction between laws that obstruct freedom and laws that contain rules and regulations for proper conduct of trade activities. 301 has a ban on illegal activities. 302 is the power of the parliament to impose restrictions, for example, the defense rules. 303 has power of the state to restrict certain activities. The important aspect of all of these articles is to make sure that neither the parliament nor the states are making any laws that provide preference to one state over the other in the interest of fair trade. And this entire concept of free trade is not relevant to this issue, Your Lordship, because this is not about goods moving between one state and another state, because these are not goods. These animals are not goods because they are protected under law. Cruelty against them is a criminal offense under the Prevention of Cruelty to Animals Act. And there is no trade, there is no buying and selling. These animals, and I can draw your attention to the photographs in my application, Your Lordship. At page 104 in IA 27. These animals are caught on the streets of Assam, Your Lordship, and some other neighboring states, but largely Assam. They're caught from the streets, bundled up in gunny sacks, their mouths tied, piled in the back of trucks and goods carriers, and brought across the state to be slaughtered here. I would allege that their slaughter and their sale of meat and all of that is also in contravention of the food safety laws, because the food safety laws prescribe a standard of how meat is to be prepared, processed, and sold. But this is not a food animal. And so those standards are not applicable because they're not meant to be slaughtered. They're not meant for human consumption. There is a definition of what animals are meant for human consumption under the regulations, and those are the animals. Dogs are not included in that. When my learned colleague brought up rabbits, when the lawmaker determined that rabbits may be safe or fit for human consumption, they were added to the list. If we were to go by the liberal interpretation of these definitions made by the petitioner, then I mean, anything can be eaten, including human. Just because it's not in the list, it can be eaten. I fail to comprehend that submission, but it seems a liberal interpretation which includes humans for consumption. In the photographs, Your Lordship, you'll see the condition of the animals, how they are kept for sale, displayed for sale, how their carcasses and parts are kept out in the open for sale. This is not trade, this is not commerce, and this is not anything that can be covered under Article 301 to 307. They are smuggled, in effect, they are smuggled across the state borders and slaughtered and sold for consumption here in very clandestine manners, which is evident when in the markets may be visited. But my submission, Your Honor, is that the Prevention of Cruelty to Animals Act has under it, and I will go through the PC Act a little bit more elaborately, and I seek your indulgence for that. But for the purposes of this submission, the Prevention of Cruelty to Animals Act has under it the animal birth control rules, which have recently been amended as well. They are yet to be placed before the Parliament, but as the rules stand, the animal birth control rules of 2001, they provide for the control of dog population, street dog population, by way of sterilization and vaccination. Absolutely right, Your Lordship. So they specifically require that no animal can be displaced from its area, from its region, and they can only be moved by the local authority or an agency authorized to carry out the sterilization and vaccination for the purposes of sterilization and vaccination, and then brought back to the same location. There is a matter that has been ongoing in the Honorable Supreme Court since 2009, SLP 691 of 2009, Your Lordship. And there are multiple orders within that reiterate this. The Supreme Court recognizes that street dogs are a part of the community, that they may be provided for, that it is the state's responsibility to ensure that they're sterilized and vaccinated in the interest of their welfare and also in the interest of public health. These animals cannot be relocated. There is a standard that is prescribed by the Animal Welfare Board of India via the revised module for street dog population management, eradication of rabies, and reduction of man-dog conflict. Upon direction of the Honorable Supreme Court, the Animal Welfare Board of India, a statutory body established under the Prevention of Cruelty to Animals Act, submitted this module to the Supreme Court, and the Honorable Supreme Court was pleased to direct that the module be followed. They expressly held that no subterfuge can be taken in lieu of carrying out the ABC rules as they stand. No relocation, no killing, because, Your Ladyship, we have seen that just relocation does not mean nature does not like vacuum. If animals are removed from a certain area, some other animals will occupy that area. So removing perfectly sterilized, vaccinated dogs from a region, and these animals are sterilized and vaccinated with resources of the state. So where there are sterilized and vaccinated animals, if they are removed, then other animals occupy that state which may or may not be vaccinated. There is also no way to verify that the dogs that are being smuggled across the state border are vaccinated. And that's my other contention with relation to the presumed belief that consumption of dog meat is healthy. But this in no way is trade or commerce. This is illegal, and it is very evident in the fourth cross-relation.
But vaccination is sterilization, isn't it, for their reproduction because of the menace of stray dogs?
Yes, Your Lordship, that's the only scientific way to control dog population. It has been deliberated, and there have been many instances where dogs are culled in large numbers, but that has never resolved it. It is all of the science and recognition of what the recommendations of the World Health Organization is and the recommendations of the Animal Welfare Board. Lordship, a few decades ago in Surat, Gujarat, it was considered that there was too much street dog population. And so a drive was conducted to eradicate the street dogs in Surat, and the local authorities successfully did that across the city. Within months, there was an outbreak of plague. And there was a lot of human casualty because of the outbreak of plague. So we recognize that every species is in the ecosystem for a reason, and there is a scientific method to ensure population management.
Then next point.
If I may come to the sections of law that were referred to, where scientific data necessary for making such a notification or order was not relied upon. If I may read the sections that were relied upon. 34 of the FSS Act provides for emergency prohibition notices and orders. This is a power of a designated officer, not the authority as a whole. The designated officer is satisfied that a health risk condition exists with respect to any food business, a food business that is existing. He may, after a notice served on the food business operator, issue an emergency prohibition notice. And there is a procedure for that. Then 36 again provides for powers of the designated officer, the Commissioner of Food Safety, the provision for appointing a designated officer. Then the powers of the food safety officer. All of these are relevant only to instances where legal recognized licensed food businesses have any violation. And in that case, what are the powers of the authority to either respond to that violation or to set it right? It has nothing to do with creating regulations or enforcing those regulations. Those powers are restricted to 16 read with 92 and 93. These provisions are completely irrelevant and they do not form the criteria. The criteria to form regulations are within 92 and 16 and 93. This is the responsibility of a designated officer for existing food businesses where there are violations. With relation to custom, Your Lordship, again, I have made overarching submission that there are certain criteria for what may be considered as custom, and the citations made by the petitioner are mere articles or books. They are by no stretch of imagination can they be considered historical accounts. They are anecdotal observations of individuals that may have served here for a duration of time, that may have been engaged with the community, but that cannot be considered a historical account. It is observations of one individual, and they are books published by Macmillan Publishers. This is not a scientific journal. This is not a study. This is not peer-reviewed research. It is not a historical account. That apart, there are several orders of the Honorable Supreme Court, even with relation to Sabrimala, that was more recent. But there is a criteria as to what can be a custom and whether custom takes precedence over any other laws. And in case of a conflict, what takes precedence? In Saraswati Ammal versus Jagadambal and another, AIR 1953, SC 2001.
Give me the citation.
It is AIR 153.
Where have you? Do you have it with you?
I don't, Your Lordship. I have extracts of that. I have not had any resources here to be able to get copies. So
You
I'm.
just list them down. You give it to the library, and they give it to you.
I'll do that, Your Ladyship. I was not familiar. I should have done that. My apologies.
Yes, you could have this thing. Anyways,
If I may read out the extract.
AIR
AIR 1953.
1953. Give me the extract. You Xerox it and underline the portion you read.
I'll do that, Your Ladyship. Page 201. It's para 10 that I'm referring to. It is incumbent on a party setting up a custom to allege and prove the custom on which he relies. It is well settled that custom cannot be extended by analogy. It must be established inductively, not deductively, and it cannot be established by a priori method. Theory and custom are antithesis. Custom cannot be a matter of mere theory, but must always be a matter of fact, and one custom cannot be deduced from another.
Do you have that in your this thing? In your IE?
In my iPad, yes, Your Lordship, I can.
In your IE, where is it?
I can pass it over.
Have you mentioned that in your IE? I'm just saying.
No, Your Lordship, I'm making these citations in response to the additional submissions that the petitioner made yesterday.
Then you'll have to give me a Xerox copy of that.
I'll do that, yeah.
Underline the relevant paragraphs. You were here this whole yesterday, today also. You could have taken the trouble
Yes,
to go
yeah.
to the library and ask for the citation.
I apologize, Your Lordship.
Yes.
Right. I'm also referring to Salek Chand versus Satya Gupta and others. SLP. The citation, Your Lordship, is 2008 13 SCC 119. all that is necessary to prove that the customer usage has been acted upon in practice for such a long period and with such invariability and continuity as to show that it has by common consent been submitted to as the established governing rule in any local area, tribe, community, group, or family. Certainty and reasonableness are indispensable elements of rule. For determination of the question whether there is a valid custom or not, it has been emphasized that it must not be opposed to public policy. I'll provide extracts on a piece of paper along with the citation, Your Lordship, shortly. But the purpose of my submission, Your Lordship, that again, these are not historical accounts. They are books that are published in 1920 and 1930. The usage is neither established invariably and it is not countenanced in law. That apart, customs must evolve with society. It cannot be that we had practices or uses or beliefs that are dated. As Your Lordship correctly posed the question of what the benefits of dog meat are, I can certainly state that there are no specific benefits to dog meat. There is no science, no literature, no research that indicates any benefit of eating dog meat. On the contrary, there are science, literature, peer-reviewed papers, publications of the recent past that indicate the risks, the health risks, the risk of zoonosis because of this practice. I draw your attention to page 20 of my IA, Lordship.
Yes.
In research paper, assessment of risk of possible exposure to rabies among processors and consumers of dog meat in Zaria, Kafanchan, Kaduna State in Nigeria. Rabies is 100% fatal disease. It is a reportable disease. There is absolutely no cure for rabies. All of the studies that I'm citing have proven that the trade of stray dogs is fueled by consumption and it is a major risk factor of disease. Stray dog trade fueled by dog meat consumption is a risk factor for rabies infection in southern Nigeria. This is published in African Health Sciences. All of these are leading scientific journals, Your Ladyship. And this was published in 2013. All of these studies are conducted in areas where there is consumption of dog meat. Rabies is universal and almost uniform in mortality. Recent survival rate of 8% has been claimed in the United States. The 10 cases of rabies reported within 5 months in a referral center, which serves a population of only 2.9 million, is an epidemic and may represent tip of the iceberg. It is the catching of the dog, the transport of the dogs, the handling of the dogs when they're being slaughtered, especially the slaughter method observed here, and there are photographs to that effect also. The process for slaughter is to bring the dog out, take off the mouth tie, and bludgeon it to death. Hit it over the head with a heavy cudgel or a stick, and then use a flamethrower to get rid of its hair. In some cases, the animal is unconscious but still alive while it is being torched. All of this exposes the people that are transporting the animals, the people that are catching the animals, the people that are slaughtering the animals, and likely in some cases, the people that are consuming the animals. And I reiterate to your ladyship, there is no known cure for rabies. I have had the misfortune of witnessing firsthand what rabies in humans look like, and I would not wish it on anybody, your ladyship. The research paper, Outbreaks of Human Trichinosis Caused by Consumption of Dog Meat in China. Dog meat has become an important source of trichinella infection for humans in China. There have been 81 cases in 5 outbreaks. Multiple cases. The epidemiological surveys were performed in 9 provinces of China among 19,662 dog samples. The prevalence ranged from 7% to 39.5%, with an overall prevalence of 21.1%. The study also recognized that freezing of the meat or treating it any different way did not get rid of the bacteria. And people that consumed it, even after a certain amount of time, were still exposed to the infection. May I go on, Your Lordship?
Yes.
In research paper, rabies virus in slaughtered dogs for meat consumption in Ghana, a potential risk for rabies transmission. Rabies is one of the most dreaded viral zoonotic diseases due to its high case fatality rate and affects multi-host mammalian species worldwide. It manifests as an acute progressive
So
encephalitis.
you're saying that you get rabies by eating dog's meat?
There are research
Or
papers
if
that
the dog
indicate.
is infected with rabies?
Yes, Your Lordship, because these
If the
dogs.
dog is not infected with rabies, is there a chance of still getting rabies?
No, in the manner that the dogs are crowded together, transported,
Okay.
the transmission is highly possible, especially in the conditions that the animals are transported. Again, all of these are street dogs. Most of them likely not vaccinated. They're exposed to each other, kept in close confinement, constantly tied up, and with
Okay, so you're saying they're exposed to being infected by rabies, and
yes,
therefore
and the
there is more
transmission.
human
Absolutely, Your
complications.
Lordship.
Okay, fine. Then
Your Lordship, the risk of rabies virus is not alone, or the trachinella infection is not alone. The condition of the market, as the regulations for food safety, for standards, for the hygiene, licensing and regulation, the infrastructure that are required for meat shop, etc., are there to avoid risk of zoonosis and risk of diseases. The rules, the chapter 4 under the food safety regulations for licensing and registration of food businesses require, for a reason, that live animals are not kept where where animal meat is being sold. It is because the risk of transmission is high. There is enough and more evidence that the abrupt and life-threatening pandemic, which seems to be making a comeback, also originated due to the operation of illegal wet markets in Wuhan, selling various animals for consumption. And it is not just Wuhan, Your Lordship. I had the opportunity to go to the Natural History Museum in Smithsonian, and there is a section especially for pandemics and epidemics. And the entire section is created only of cages with stuffed animals stacked one on top of the other, a variety of species in such close confinement. Viruses may be dormant in some species, but when transferred to other species may wreak havoc. The risk of rabies and trachinella, again, is not the only limitation. There may be so many other diseases and outbreaks. The potential of that in wet markets, in meat markets, where live animals, dead animals, stressed animals that are transported in the manner that they're transported are kept and are highly susceptible to diseases. Your Lordship, I'll also make reference to one more citation. The Honorable Supreme Court in Animal Welfare Board of India versus A. Nagaraja, the citation is 2014-7 SEC 547. It made an observation about the statutory rights of animals to be parallel to the fundamental rights that we enjoy under Article 21. The court observed that in para 72, observed that animals have some worth beyond the intrinsic value of they have some intrinsic value beyond the utilization that we have for them. Of course, there is some exception in the Prevention of Cruelty to Animals Act, but those exceptions also come with certain limitations. The Prevention of Cruelty to Animals Act, Your Lordship, is made with the purpose to prevent unnecessary pain and suffering in animals. Section 11, the purpose of the definition of animal in this, Your Lordship, this is similar to the definition of animals in the Indian Penal Code as well. It includes all animals except human beings. And that is for the purpose that this act aims to protect animals, a special legislation, which is separate from the food safety law, which is to ensure food safety. The Prevention of Cruelty to Animals Act establishes a statutory body, the Animal Welfare Board of India, which is well suited to advise the Government of India on progress of policies to ensure prevention of cruelty to animals. The doctrine of necessity was pointed out, that there are exceptions where there is necessity, where there is human necessity. While Section 11.1 provides from A to O what actions and omissions amount to cruelty, Section 11.3 provides for exemption. And for the sake of this petition,
Yes, Section
3E,
11.3.
11.3.
Wait, where is it? The CPC Act? Prevention of Cruelty. Yes. 11.3.
I draw your attention to 11.3E, my lady.
3E. Yes.
Nothing in this section shall apply to the commission or omission of any act in the course of destruction or the preparation for destruction of any animals as food for mankind, unless such destruction or preparation was accompanied by the infliction of unnecessary pain and suffering. The key words being unless such destruction or preparation was accompanied by infliction of unnecessary pain and suffering. In furtherance of this, under Section 38, where there is authority to the central government to make rules under this act, the Government of India notified the Slaughterhouse Rules of 2001. My learned colleague pointed these rules out to you yesterday, Your Lordship, but I think there was again reading just in silos.
Yes. Section 11.3.
Sorry, Your Lordship, 1 minute to find the page. Yes. There is a prohibition on slaughter anywhere except in recognized or licensed slaughterhouses.
Where's that?
In Rule 3, Your Ladyship, of slaughterhouse rules. The same is a requirement under the food safety law as well. As I said, the standards are there because they prescribe a certain infrastructure to ensure that the food is safe and the environment is protected, to ensure that there is proper waste management, that the animals are slaughtered in a manner that minimizes pain and suffering.
Where are you reading?
Slaughterhouse rules, Rule 3, Your Ladyship,
Slaughterhouse Rules.
under the Prevention of Cruelty to Animals Act.
It's interesting because we don't really.
Can I pass my copy over, Your Lordship?
Wait, I have it here. Slaughterhouse Rules 2001.
2001.
Okay, so you're reading from?
I'm reading Rule 3, Your Lady.
Rule 3.
Animals not to be slaughtered except in recognized or licensed slaughterhouses. No person shall slaughter any animal within a municipal area except in a slaughterhouse recognized or licensed by the concerned authority empowered under law for the time being enforced to do so. The concerned authority for the laws in force is the Food Safety and Standards Authority. The Food Safety and Standards Authority is the licensing registration authority for this purpose. No animal which is pregnant or has an offspring less than 3 months old, is under the age of 3 months, has not been certified by a veterinary doctor that it is in a fit condition to be slaughtered. These standards, these rules are in place to ensure that sick and diseased animals are not being slaughtered and then consumed. That it also provides briefly the infrastructure of a slaughterhouse, that there must be a resting area, resting grounds for animals before they are slaughtered. So they're not highly stressed before slaughter, because when animals, including humans, are stressed, we are more susceptible to diseases or infections. What the slaughterhouse building is to look like, what the slaughter process should be, what lairages, all of this is provided for. So to say that there are no standards that regulate slaughter would be misguided and ill-conceived. The standards are there in the Prevention of Cruelty to Animals Act. They're also in Chapter 4 of the Licensing and Registration of Food Businesses Regulations 2011. Your Ladyship, comparing the Prevention of Cruelty to Animals Act and the Food Safety, as I've already established, is comparing apples and oranges. The purposes of both laws are separate. The purpose they serve is separate. But both collectively regulate slaughter, one with the perspective of welfare, the other with the perspective of food safety, but they overlap to a large extent. Because a healthy animal may be safe to consume, but a sick animal is not. The reference made to Wildlife Protection Act again is uncertain. There is no prohibition in Wildlife Protection Act because the Wildlife Protection Act recognizes certain species of animals in the schedule that are accorded the protection that the Act provides. Wild animals cannot be, the definition of hunting is wide in Section 9 of the Wildlife Protection Act. It cannot, the animals cannot be kept in captivity. They cannot be in possession of an individual, far from being slaughtered. The definition of hunting includes knocking down a tree which may have protected species nesting on it. And so the Wildlife Protection Act, I just want to submit that it's not relevant to the purposes of this petition.
What about these exotic animals? The amendment of the Wildlife Protection Act, any update on that?
So amendment has been made to the Wildlife Protection Act, Your Ladyship, to include certain exotic species. There is a CITES, the Convention on International Trade of Endangered Species, that India is a signatory to.
It's okay, I'm just curious.
No, I understand. So the CITES regulates the incoming and outgoing of exotic species of animals. They don't have the same protection under the Wildlife Protection Act, but they're protected again by the Prevention of Cruelty to Animals Act, which does not make a distinction between domestic animal or wild animal or so on and so forth. So all animals, whether they are native to the country or not, have protection under the Prevention of Cruelty to Animals Act, whereas the scheduled animals in the Wildlife Protection Act enjoy the protection under WLPA. Your Ladyship, that's the gist of my arguments. I will just quickly go over. I'll take 7 more minutes and seek your indulgence, Your Ladyship. The welfare of animals, Your Ladyship, predates the Prevention of Cruelty to Animals Act. It came in 1960 with the purpose of preventing unnecessary pain and suffering. And the transition, the evolving of the jurisprudence is very evident from the statement and objective of the Act. Exactly 100 years before, the colonial legislation that existed, the Prevention of Cruelty to Animals Act 1890, only provided for protection of animals against cruelty if such an act of cruelty was committed in public. Anything that was committed within private residences was not considered cruelty. Recognizing that we have compassion, that recognizing that animals have some intrinsic worth, the Prevention of Cruelty to Animals Act was repealed and reintroduced in 1960. And that is because India is one of the very few countries.
Let's stick to the subject because I know you are very thorough with what you're doing, representing the.
No, Ladyship, I'm just providing the basis.
Yes, let's stick to the case. The present
I'm
case.
providing the basis of the
Background.
constitutional provision for animal protection and why
So you're
standards for
saying
food
these
safety.
Dogs need to be protected too.
They
That's your
have.
point.
My point is that that it is our fundamental duty to have compassion for all creatures. I'm saying that the process of capture, transport, slaughter, while blatantly illegal under the food safety and standards regulations, is also cruelty under the Act and in contravention of the constitutional principles and the duties that are laid on us by the Constitution
Okay,
in
so-
51 AG.
So the notification that has been issued is not to be interfered. Is that your point?
That is my point, Your Ladyship, and the
fine.
notification as well as the circular, and I'll just read that notification, Your Ladyship.
Yes, where's the notification?
It's in the original writ, Your Ladyship, in the amended writ. There are no page numbers. 52, Your Ladyship.
Yes. Page 52 of the original writ. Amended petition, is it?
Yes, Your Lordship.
Yes. What does the notification say? Yes.
Whereas the central government, Ministry of Health and Family Welfare, enacted the Food Safety and Standards Act 2006 and the Food Safety and Standards, Food Product Standards and Food Additives Regulations 2011 to regulate the safety of food articles safe for human consumption. And whereas in Regulation 2.5.1A of the Food Safety and Standards Authority Regulations 2011, meat and meat products, and as per Subregulation 2.5.1A of the Regulation 2011, animal means an animal belonging to any of the species specified below, ovines, caprines, salines, bovines, and includes poultry and fish. And whereas the slaughtering of any other species other than the ones listed in the sub-regulation is not permissible under the Act and regulations. Whereas for strict compliance of the Food Safety and Standards Act and regulation, in order to regulate safety of food articles for human consumption, it is necessary to ban slaughter and sale of dog meat in the state of Nagaland. Now, therefore, in consonance with the provisions of the Act and the regulation, the following are banned with immediate effect: commercial import and trading of dogs in dog markets, commercial sale of dog meat in markets, and dine-in restaurant. Any person found violating this order shall be liable to be punished, so on and so forth. At page 58, Your Ladyship, is the 2014 circular of the Food Safety of the Directorate of Enforcement, Food Safety and Standards Authority, which has also been assailed. Slaughtering of animals not permissible under the Food Safety Act and regulations. Your kind attention is invited towards Regulation 2.5 of the FSS Food Product Standards and Food Additives Regulations 2011, wherein definition of animals, carcass, and meat are given. As per Subregulation 2.5.1, animal means any animal belonging to any of the species specified below, ovines, caprines, salines, bovines, and includes poultry and fish. The slaughtering of animals of any other species other than the ones listed above is not permissible under the Food Safety Act and regulations. In the view of the above, you are requested to kindly strengthen the vigil and ensure the compliance of the provisions of the Act. It is a verbatim reproduction of the regulation and a direction to enforce that regulation. There is no interpretation, Your Lordship. And it may seem an interpretation if the provision, the definition provision is read in silos, just A is read, but it is also followed by the definition of meat. What is construed to be meat means all edible parts, including edible offal, of any food animal slaughtered in an abattoir that are intended for or have been judged as safe and suitable for human consumption. The requirement being that the animals are slaughtered in accordance with the prescribed standards, and only meat coming from these animals which are slaughtered and processed and sold in the manner prescribed in law may be construed as meat. It would be misguided to call this an interpretation, which is a simple directive, which is the responsibility of the executive to enforce the existing law. My last submission, Your Ladyship, is that I take complete opposition to the submission that this is an interpretation. It is not an interpretation. I take opposition, and I absolutely agree with the submission made in the counter to respondents 1 and 2 that other animals are also being slaughtered. There is no discrimination. The state chose to bring this law about, refer to this law, and issue a certain ban because the dog is not a food animal. It's not within the definition of a food animal. Other animals are also being slaughtered, and that may be seen in, and they're not being slaughtered. Even the animals that are allowed to be slaughtered for, are meant for human consumption, are not being slaughtered, sold in accordance with the prescribed standards. There are two aspects. There is violation of the prescribed standard by not following those standards to ensure safe food, to ensure sanitation. And then there is complete dereliction from the regulations itself by slaughtering animals that are not meant for human consumption. So that may be treated separately. The other animals that are being slaughtered, that are allowed to be slaughtered, it is the state government's responsibility again to enforce the standards to ensure safe food. And we take the same opposition to all the species of animals that are not determined to be food animals and are still consumed, because there is no governing, no regulation, no way in which the Food Safety Authority can govern the consumption of these species. They can govern, they determine that these are the species that are fit for human consumption, and they've prescribed standards on how to go about governing them. That's my last submission, Your Ladyship. I'd be happy to provide any clarifications.
Yes. So let's hear the other respondents.
Yes.
Since we have taken a lot of time now. State respondent is respondent number?
1 and 2. 1 and 2.
1 and 2.
Yes. Lordship, I'll just read my affidavit. Lordship, can you turn to my affidavit?
Yes.
Yes. Page 2.
Filed on 28th June
Yes,
2022. Yes. Yes.
No, I filed it on 9th of 12th, 2020.
Pardon?
I filed it on 9th.
Affidavit in reply.
Affidavit
Okay,
in opposition,
this
yes.
is affidavit in reply to the opposition. Wait. Affidavit in opposition, behalf 4 and 5.
1 and 2, for 1 and
Just
2.
This is affidavit in reply. Yes, affidavit in opposition by 4 and 5. Yes.
Page 2, para 3. Yes.
Yes.
This is a preliminary grounds. I may be allowed to read?
Yes.
That the government of Nagaland had issued a notification number such and such dated 4/7/2020 under challenge after due approval of the cabinet, reiterating the position of law with regard to import, trading, and sale of dogs for the purpose of human consumption as contained in the Food Safety and Standard Act 2006 and the Food Safety and Standard Regulation 2011. Then Lordship may come to page 4, para 3.3. That regulation 2.5 of the regulations deals with meat and meat products. The said regulation laid down the meat and meat products that can be inter alia distributed, sold, or imported as food and placed in the market for human consumption. Regulation 2.5.1 clause A of the said set of regulation defines animal as follows. Animals means an animal belonging to
Yes,
any of
that
the
we
species.
have read
Yes,
on and
I
off
don't need-
again. Yes.
Then
Definition of
3.4.
animals.
Yes, 3.4.
3.4.
That with regard to the slaughtering of animals not permissible under the Act and regulation, the authority had issued a letter number such and such dated 6/8/14, wherein it has been clearly mentioned that slaughtering of animals of any other species other than the one listed in regulation 2.5 1 clause A of the Food Safety and Standard Food Products Standard and Food Activities Addictive Regulation 2011 is not permissible under the FSS Act and
Yes.
Regulation. 3.5. That the Cabinet deliberated on instances coming to light of import and commercial sale of dog and dog meat in the state. The Cabinet observed that dog meat falls within the family of canine, which is excluded from the provision of Regulation 2.5d A of FSSI Regulation 2011, which regulates and defines the meat for sale and consumption, and thus the existing law does not permit the slaughter, sale, and consumption of dog meat in the country. The Cabinet, after due deliberation, decided for issuance of orders banning the following: 1. Commercial import and trading of dogs and dogs meat. 2. Commercial sale of dogs meat in market and dine in restaurant. Lordship, page 14 is the Cabinet memorandum, meeting minutes of the Cabinet, Lordship. Yes. In order to save time, I may not read. Yes. Then come to para 3.6, page 5. The power for regulating the distribution, sale, or import of animals, including dogs and dog meat, is with the authority. And the said regulation not permitting the distribution, sale, or import of dogs have been issued by the authority. Dogs which are not animals covered under specific defined under the regulations are therefore not permissible to be distributed, sold, or imported for human consumption under the Act as per the regulations issued by the authority. The state government notified reiterates the above facts only. Then, Lordship, may kindly come to para.
Wait, 3.6. So you're saying
Yes.
with the authority. So you're
Yes.
saying this authority mentioned here
Yes.
means the CS, Chief Secretary.
No. The
Then?
authority means the Food Security Authority.
food
Yes, Lordship.
security.
Yes, because they have issued us the letter, Your Lordship, that is at page 13.
Okay,
And
food
it's-
security. So you're referring to the circular that was given
Yes,
to you. Dated
6/8/2014.
6/8/2014.
Yes.
Okay, fine.
Then, Lordship, may kindly come to para 6, page 6.
Yes.
That with regard to the statement making such and such, in order to avoid repetition, the deponent reiterates and reaffirms the statement made in the preliminary grounds. The deponent further stake is under A. The right to do business as per Article 19(1)(g) is subject to reasonable restriction imposed under Article 19(6) of the Constitution. B. Article 19(6) of the Constitution provides that nothing stated in Article 19(1) clause G shall prevent the state from making any law imposing reasonable restriction in the interest of the general public. C. Though the Constitution has given complete freedom to practice or carry on any occupation, trade, or business, the state government has a right to impose complete restriction on the said right if the same is in the interest of general public and protecting the common good of the people. Then number D. As already stated, the said notification dated 4/7/2020 is in conformity with the Act and regulation and based on the policy decision taken by the state government. The deponent therefore denies the contention of the petitioner that their fundamental right to trade, sell, and eat dog meat has been illegally and constitutionally robbed by the state. So, Your Lordship, these are my affidavit, Your Lordship. So, what the state issued that notification dated 14 July 2020, that is in consonance with the Act as well as the regulation. That's my submission,
Yes.
Lordship.
Yes. Food safety. Your respondent number?
May I please, Your Ladyship, for respondent number 4 and 5.
4 and 5.
Yeah,
Yes.
food and safety, as well as health and
Okay.
Yeah.
Health and family welfare.
health and family welfare. Your Lordship, I also filed my affidavit in opposition,
Okay.
so I'll be just reading out the affidavit.
Just a sec. Let me find the affidavit in opposition.
I filed
Yes,
on
yes.
21st June 2022. Your Lordship,
Yes. 21st.
I'll come
June,
straight
yes.
to para 7.
Para 7. Yes.
It is submitted that the Food Safety and Standard Authority of India has been established under the Food Safety and Standard Act 2006 with mandate to lay down science-based standard of articles of food and to regulate their manufacture, storage, distribution, sale, and import to ensure availability of safe and wholesome food for human consumption. Your Lordship, I'll straight.
So you're saying that dogs are not safe for human consumption. Is that your point here? To regulate and manufacture?
Yes, Your Lordship.
Okay. Yes,
And
okay.
Para 15, Your Lordship, page 9. It is submitted that the definition of carcass, offal, edible, offal tissue, meat, food products, slaughter and slaughterhouse, provided under sub-regulation 2.5.1, clause P of regulation 2.5 of food safety and standards, regulation 2011, invariably refer to food animals, that is, animal which are meant for consumption as food by humans.
So you're
Accordingly,
saying dog meat is not for consumption of humans. That's
Yes,
the conclusion,
yes,
isn't it?
Your
Last
Lordship.
line? Okay.
Yes. Accordingly, such food animals which are permitted for consumption as food by humans are listed under definition of animals in clause A of sub-regulation 2.5.1 of these regulations.
Yes.
Since the list do not include dogs or canines, such animals are not recognized or allowed as food animals as per these regulations. So, Your Lordship, my prayer before this honorable court is to dismiss the present writ petition in pass such order or further orders or direction as this honorable court may deem fit and proper. That's my submission, Your Lordship.
Yes. Are we done?
Yes, Your Lordship.
2 minutes for a short rebuttal.
What?
Your Lordship.
Rebuttal?
Yes,
To
on the
read?
submissions made by my learned friend representing the 6 and
Yes.
7 respondents, respondents
Yes.
6 and 7. On the submission and highlighting the various aspects of the dogs and the street dogs and how they are transported, this petition is not concerned with how or in what manner dogs are to be transported or street dogs are to be treated or how they are to be vaccinated or sterilized. The petition is primarily concerned with whether, as per the interpretation forwarded by the food safety and the state government, whether such interpretation is correct, whether there is any provision in the act or the regulation which prohibits the consumption or the slaughter of any other animal not mentioned in the definition. That is
Okay,
the primary issue in this petition. Secondly, the research papers and all those cited by in the IA regarding rabies and everything, such no report from India is reported. And even if there is any report of India, my submission is that it will have to be the duty of the food safety officers or the other concerned authorities entrusted with this to have a scientific objective data to be able to come to a conclusion that yes, consumption of eating dog meat leads to rabies. Insofar as this petition is concerned, no such report has been provided. Thirdly, my learned friend also referred to section 3 of the Prevention of Cruelty to Animals Act, wherein provisions have been enacted on how to maintain slaughterhouse rules and everything, how to be hygienic. But this petition again is not concerned with that. If I am in any manner violating the slaughterhouse rules, then I can be punished by the concerned authority. I'm not concerned with that. Fourthly, with reference to the customs, the books which I've relied on in my yesterday, I have shown Your Lordship the 4 books written by those authors. In that regard, my submission is that under Section 57 of the Indian Evidence Act, this court can take judicial notice of those books because those books records the first anthropological and ethnographical history of the Nagas. And
Let's read 57.
57,
Indian Evidence Act.
57, Evidence Act.
Okay.
Or I can
57,
read out.
which
oh,
one?
okay. 57, facts of which court must take judicial
Yes.
notice. So, in the
Which point?
after subclause 13, in all these cases,
13,
and
13,
also
yes.
on all matters of public history, literature, science, or art, the
Okay.
court may resort.
In all these, and also in matters of public history,
Yes.
literature, science,
Or art.
or art.
This court may resort for its aid to
So
appropriate
you're
groups of
saying that this is public history and literature?
Yes, I'm saying that this is public history of the Nagas.
Okay.
One of the first, if not. And earlier in the authorities relied upon, I failed to mention one. I failed to bring one authority before your lordship. May I place that one? I'll just read out one page. Okay, this is reported.
This is how I want you to give me the authorities, okay?
I'll do so, Your Lordship.
Xerox them and underline the portion you're
I'll do so. I'll do so.
facing your argument, yes.
This
If
was
you don't
Yes,
have
sir.
the book.
2017 SSC Online, Calcutta, 16323. Just one paragraph, 46. Although I'm also relying on 40 and 41.
Yes, 46.
46, the short 4 lines only. FSSA is a regulatory statute.
Hmm.
It empowers the authority to regulate the manufacture, storage, distribution, sale, and import of food products for human consumption. Such regulatory power does not authorize the authorities to prohibit the manufacture of tobacco or tobacco products, even if the same can be called food. In this case, the issue was between the conflict between the Kotpa.
Concerning tobacco, okay.
Yes. So even
okay.
if tobacco can be described as food, it cannot be prohibited. That was the conclusion
Okay,
drawn by the
okay.
Honorable High Court of Calcutta. That concludes my submission. I'm obliged, Your Lordship.
Fine. We'll make it a CAV. I will consider your submissions. After such a long argument, almost 2 days, I would not be doing justice to neither of you if I conclude and make a decision straight
Yeah,
away.
Lordship.
I think I need to ponder too, isn't it? Yes. Heard Mr.
L. Iralu for the petition.
Elirali, Learned Counsel for the petitioners, along with Miss, your good name, please?
Shreya Parupkari,
Shreya Parukari, Learned Counsel for respondents number
6 and 7.
6 and 7, comma. Miss
Dimanaro.
Dimanaro, Learned Counsel for respondent number 4 and 5, and Miss Shuri, Learned additional AG for the state respondents number 1, 2, 2. Hearing is complete. Matter is reserved for judgment. Yes.
Your Ladyship, I just want to point to the stay order. My submission was that the enforcement over existing central legislation is effectively encumbered because of a stay on a notification, which is only directing enforcement of the
Yes,
central
yes,
legislation.
yes, yes.
So I may seek a shorter date, Your Ladyship.
That depends on the time that I have. Is it a short
Absolutely.
date for what?
But
Let me ponder. I have other CAVs also pending. But
Absolutely,
it will
absolutely.
come out, okay,
But
when it
I just
remove
beg
the
that.
state order.
Absolutely, Your Ladyship. I'm not even
Heavens will
pressing
not
on that.
fall.
I'm
Heavens
just
will not
seeking,
fall.
I'm very grateful for your indulgence so far. I'm just seeking your consideration.